Good afternoon, everyone. We are here for closing arguments in the Robert Tellis trial. Thank you, everyone, for joining us. We looks like we've got Natalie and Miss Carol in the room. Good to see you both here. This has been quite the whirlwind of a trial. The prosecution put on quite a bit of evidence regarding Mr. Tellis's alleged guilt here, and some of that evidence was direct evidence, including the DNA evidence that they put on. And then the defense got up and really was unable to do anything with respect to the majority of that evidence, other than to allege a huge, sweeping conspiracy theory involving a private entity, this real estate group, quite a number of members of the Las Vegas Metropolitan Police Department. Hey, Jeff, good to see you here as well. The district attorney, crime scene investigators, the DNA lab, everybody apparently in the state of Nevada was involved in this conspiracy, not only to murder Jeff Gehrman, but also to frame Robert Tellis for that crime. And today we're going to hear the closing arguments from the prosecution and the defense attorney. Now, I'm interested to see if the closing arguments from the defense attorney are going to include those arguments that we heard from Robert Tellis in his own defense. Is he going to get into the specifics of this conspiracy theory that they have put on little to no evidence to show actually existed? What is he going to have to say about that if he is the one that's going to be doing the closing arguments? I can't imagine that Robert Tellis is going to be doing his own closing arguments. So it's likely going to be his defense attorney, but only time will tell, I guess. And I can't see what the defense attorney would have to say about this massive conspiracy allegation. But even without that, the prosecution's closing arguments are likely going to tie everything that we have seen up to this point together, wrap it up for the jury, and put a nice bow on top. So, and again, the defense is not going to be able to do that. They don't have any package to deliver to the jury that I can tell. All that they've been able to do is try to kind of poke holes in some of the things that the prosecution has said, but in my view, they haven't poked enough holes to be able to give the jurors reasonable doubt as to Tellis's alleged guilt. And Robert Tellis was unable to do that. We didn't see anything from Robert Tellis other than, I didn't do it. The shoes aren't mine. The hat's not mine. There's no the car that the assailant used wasn't mine. There's no DNA in my car. Essentially, all of this must be a massive conspiracy, essentially because I have to disregard all of the evidence in order to demonstrate the fact that I'm not guilty. Therefore, all of the evidence must be made up. And in sum, this must be a conspiracy if all of the evidence against me is made up. And that to me just isn't something that defendants can do. Because if they're allowed to do it, if they're allowed to say all the evidence against me is made up, even though I can't prove that any of the evidence against me was made up, then throw out the court system, throw out our criminal justice system. Because every defendant will from this point forward, be able to raise the conspiracy defense and prevail. There has to be some evidence of a conspiracy, some actual thing you can point to and say, look, here's the conspiracy. And even though I can't prove every part of it, here's the parts I can prove. And we didn't get that from Robert Tellis. We didn't get that from his defense attorney. All we got was allegations of a massive conspiracy without any direct evidence, without even any circumstantial evidence of a conspiracy. I mean, the biggest thing that they were able to say was that Detective Jappy was present for a lot of the things, but he was never present for the things that could have amounted to instances where evidence could be planted. He didn't show up to the scene of the crime to plant DNA evidence on Jeff Gehrman. He didn't show up to Tellis's house when they effectuated that search warrant to plant the shoes or plant the hat. He was at the office of Robert Tellis, coincidentally, at the same time that the murder investigators were at the office of Robert Tellis. But according to several witnesses, he wasn't near them. They didn't know what he was doing. He was conducting his own investigation at the behest of Robert Tellis, while others with the Las Vegas Police Department were conducting their investigation into the crime that he's on trial for. There's no indication that anybody allowed him into the areas that the criminal investigators were investigating, that he had anything to do with this information being pulled off of Robert Tellis's computer, the information showing that he conducted his own investigation into Jeff Gehrman from his office computer, allegedly, using his password, his username, during regular public administrator office hours, a time when people from the outside would not have been able to gain access to his computer. There were these searches conducted, and there's no indication that Detective Jappy is the one that went in and altered his computer such that we would find these searches. These searches were somehow planted there. And Detective Jappy, according to Robert Tellis, was one of the primary figures in this conspiracy, but there's nothing linking him to it. All Tellis seems to have to go on is that he asked Tellis to investigate some aspects of the public administrator's office, and in doing so, Jappy began investigating Tellis as well. Therefore, he must be conspiring against Tellis. But according to Jappy, he was following his investigation where the evidence was leading, and he had a person come and tell him, I was offered a bribe by Robert Tellis in connection with the functions of the public administrator's office. Detective Jappy has to follow that lead. To not follow that lead would be a dereliction of his duty. And the fact that he followed that lead is not evidence of a conspiracy. The fact that he didn't suggest that Robert Tellis be charged with any crime in connection with his investigation into Robert Tellis certainly isn't evidence of a conspiracy. But yet he's a central figure in this conspiracy, as is Compass Realty. And I don't recall seeing anybody from Compass Realty take the stand. I don't recall having seen any evidence of Compass Realty's dealings with the public administrator's office. All I recall is seeing Robert Tellis take the stand and tell us all about all the bad things Compass Realty did in their dealings with the public administrator's office. And we are supposed to accept not only that they did all of those bad things, but that the fact that they did all those bad things means that they too were involved in this massive conspiracy. I don't remember any district attorney taking the stand either. I don't remember seeing any evidence of the district attorney being involved in this massive conspiracy, but we are supposed to believe, based on Robert Tellis's testimony, that the fact that the district attorney received campaign contributions from people involved in Compass Realty means that they too were involved in this massive conspiracy. Robert Tellis wants us to believe that all the evidence against him is too circumstantial. It's too neat to be believable. It's so coincidental that all of these pieces are fitting together to indicate Robert Tellis's guilt. That we have to put aside all of that evidence and accept his proposition that all of it was planted and that there is some sort of a public-private partnership between all the players in Las Vegas government or Clark County government or Nevada government and Compass Realty to bring this conspiracy to life. And that's just a little much. It's a little much to swallow. Because we saw the witnesses and they were believable. Not one of them seemed to be lying about the things they were saying. Not one of the ones that were members of the governmental entities that are allegedly involved in this conspiracy. Not one of them seemed to be making their stories up. In fact, at times, the testimony they gave was adverse to the prosecution's theories of the case. They just told us, hey, this is how the office works. This is what we do. Yeah, the office kind of bumbled the evidence with respect to certain body cam footage. That kind of happened. There's really no way we can spin that. We messed that up, you know? And none of that points toward a conspiracy. The fact that all of these witnesses were believable doesn't help Robert Tellis's chances of having convinced the jury that this conspiracy exists. So now we have these closing arguments about to begin. And as I said, you know, the prosecution has a package to present to the jury, and the defense doesn't seem to have one. And so in the face of something to sink their teeth into from the prosecution, having this nebulous conspiracy as the only potential defense here doesn't speak to Robert Tellis's chances of being free as a regular citizen. much longer. It doesn't look like he's going to be going home to his family. His chances, in my view, are pretty slim. We did have a question about whether it takes just one juror, and it does. If one juror decides, I believe Robert Tellis, and I got reasonable doubt, I have at least reasonable doubt as to whether he's guilty. That's all it takes. But that juror has to stick to that. Because even if the jury comes back and says, we couldn't reach a decision, because, they don't tell us why, but essentially because there's one holdout, the judge is going to send them back and say, no, it's your job to come to a consensus here. And they're going to go back and they're going to deliberate some more. And that usually results in unanimity amongst the jurors. The instances where there are holdouts are infrequent at best. When you've got the multitude of jurors saying this person is guilty or this person is not guilty, and you've got that one holdout, it's difficult to retain your view in the face of all those other jurors saying, yeah, but what about this? And what about that? And what about this evidence? And what about that evidence? And what are you basing your decision on? Well, that doesn't make sense. When you've got all those jurors saying those things, it's very difficult to stick to your guns. So we typically don't have jurors remaining holdouts very long. So I doubt that we are going to see a hung jury in this case. Hey, Brett, good to see you could join us today. It's about 12:55. That puts it at about 10 a.m. Las Vegas time. And this was supposed to start, I believe, at 12:15, 9:15 a.m. Las Vegas time. So I would expect that they are going to be beginning here fairly soon. Miss Carol, yeah, I haven't seen his wife in the audience in the courtroom. Perhaps she was there and the cameras just didn't catch her. And, I surmised that perhaps she was not in the courtroom because the defense was going to call her as a witness. But that doesn't seem to be the case because they're done and we haven't seen her as a witness. So it could be a little telling that she hasn't made an appearance in court. Typically in these types of cases, the defense wants to humanize the defendant by having their family and their friends in the courtroom so that they can kind of get the sympathy vote. But no, she wasn't there. So perhaps she's not standing by him. Perhaps she too is wondering why all of this evidence points to Robert Tellis. But there could be any number of reasons. Perhaps she's just upset with him. I mean, she's got a lot to be upset with him about. And perhaps she doesn't want to subject the children to what we've seen, to having to see, their father on the stand admitting to marital infidelity. Perhaps she wants to shield them from having to see the prosecution put on days and days of evidence pointing to their father's guilt. Perhaps she's just trying to shield them from that. Who knows? Hopefully we do begin here soon, because after having seen 8 days of this, it's difficult to keep explaining why this person is likely going to be found guilty. The best he could come up with respect to the shoes being found in his house was that he wears risers in his shoes to work. And he told us those shoes aren't mine. They were planted there. Why would I sit and cut up shoes like that? The simple answer is because you were trying to destroy evidence. But a more in-depth answer is, well, how do you explain the fact that you admitted to having a markedly similar pair of shoes that you photographed just weeks before this incident? You admitted to it. You told us, yeah, those shoes in that picture belong to me, but the exact same pair that you see photographed as being under my recliner in my living room and having been taken by the police as evidence, that pair does not belong to me. That was planted because everybody's trying to frame me for this crime that I didn't commit. But the best I can do is tell you I don't wear name brand shoes because I put... Thanks for the sub, Rochelle. Good to see you here. Rochelle or Rachel? Looks like Rochelle, though. Thanks for the sub. The best I can tell you is I don't wear name brand shoes, except when I wear those name brand shoes that look just like the ones that the killer wore and look just like the ones the police found in my house. That's the type of testimony we got out of this defendant. And that doesn't do much to indicate that he might not have committed this crime. He tells us that this looks like a professional hit because only a professional would have been able to inflict the type of wounds that were inflicted on this particular decedent. But I think we all know that that's not the case, just based on the fact that, there were multiple wounds and very few of them were wounds that would have caused death. But one in particular that he referred to as being a professional type wound, a wound only a professional could inflict, is having his throat slashed. And I'm pretty sure that any one of us in this room could have inflicted that type of wound, even without professional training. But he pointed just to the infliction of the wound. And when the prosecution replayed the entire professional hit, we find that this professional drew attention to himself by wearing a bright orange shirt, a wide brimmed straw hat, by walking around the neighborhood aimlessly for some number of minutes before going to lie in wait for the decedent, that he parked a good distance away, but then drove the car back to the scene of the crime to go check on something, we know not what, and that he did it all in broad daylight. With a camera watching him from across the street. The prosecution kind of indicated this doesn't seem like something a professional hitman would do. But Tellus said, well, that's because this professional hitman and all of the people involved in this conspiracy wanted to make it look like it wasn't a professional hit and that I had done it. So they did all of that to make it look unprofessional. But when you look at the actual wounds, those indicate that it was a professional. And it's just so unbelievable. It's so unbelievable. Ms. Carroll says, do you think the jury's decision would have been more difficult if he had not taken the stand? I don't think so. I think that the jury wanted to hear what he had to say because perhaps there was something he could have said in his own defense that would have given them reasonable doubt. But I don't see anything that he said as making it more or less difficult for them to convict him. I think what he said just drove home the point that there's way too much evidence against him not to find him guilty. The only way he could deal with the DNA evidence is by saying it was a conspiracy. But we got this long, convoluted story about how he inflicted this wound on his finger when he was making dinner for his daughter. And he went on to instead of just leaving it at, look, I cut myself while I was cooking. That's how that wound was inflicted. Instead of just leaving it at that, he had to tell us how the blood got on the scissors. And he tells us about how he crazy glued his wound. We saw that wound. That looks like something that you would probably, if you felt the need to crazy glue it, you should probably get some medical attention for it. But he didn't go get medical attention for it. If all he was doing when that wound was inflicted was cooking, he could have stopped cooking when he inflicted that wound on himself and gone to the urgent care center. But he didn't. So giving us that long story about how the blood got on these scissors that I don't think anyone had even seen as a part of this crime. But he had to tell us how the blood got on these scissors. And so then he had to say I was cutting the top off some crazy glue so that I could crazy glue my finger wound closed. And it was just too much. So, yeah, Wesley says It was Tellus who shot himself in the foot by taking the stand. And I agree that it wasn't helpful to him. But I don't think that their job was less difficult before he took the stand. I still think that the evidence against him was kind of insurmountable. There were too many pieces that fit too well together. That when you couple all those pieces with the direct DNA evidence, I don't think that their job was difficult in the first place. And so I don't think that his testimony made their job easier, because it was already too easy. I think it could have, depending on what he said, I think that he could have made their job more difficult, but I don't think it could have gone in the other direction. I don't think it could have made their job easier. But his testimony certainly didn't help him. His testimony was, I mean, if we weren't dealing with something as gut-wrenching as the murder that we saw took place, his testimony would almost have been comical. The point at which he told the jury in error, I'm 6 feet 5 inches tall, and I wear these risers in my shoes for vanity's sake. It would have almost been comical. It would have been comical in any other circumstance. And for a juror to come back and ask him the question, how tall are you? That too would have been somewhat comical. The juror is essentially saying, are you really going to tell us this lie that you're 6 feet 5 inches tall? Are you going to maintain it in the face of this question? He didn't. But it does point to the fact that the jury is paying attention to what he's saying, and they're finding at least that bit unbelievable, because he's standing right in front of them saying, I'm 6 feet 5.5 inches tall. But based on everything I'm saying, if the jury comes back and finds this guy not guilty, I'm going to look like the biggest idiot in the world. I hope that doesn't happen. Not for my sake, but we did see the family members of Jeff Gehrman in the courtroom. And for the sake of what I see as justice being done, and for the sake of giving them the closure that they need, that I think that they need, I certainly hope that I'm not wrong. What do you all think? Do you think he has a chance? Do you think this jury is going to find that he is not guilty of this crime? There he is, apparently coming into the courtroom. Do you think he did this? Based on the evidence that we've all seen. I find it very difficult to believe that all of this evidence was planted, that somebody conspired to frame him by going out and renting or buying or borrowing an automobile that looks like his, that They drove it around the community, that they did it on a day when his cell phone, they knew his cell phone was just going to stay sitting right in his house. Somehow they knew this and committed the crime on that very day. Jeff says guilty. Carol says she thinks he did it. And she also says she doesn't think there's any chance that the jury could find him not guilty. They've been paying too much attention. They've been paying too close attention. And we have seen that. We've seen them asking questions of a lot of witnesses. And their questions were apparently good enough to get past both the prosecution and the defense, because they can object to those questions being asked. They can say those questions are irrelevant. Any of the objections that they would have, that the prosecution would have to a defense question, or that the defense would have to a prosecutor's question, they can have to the jurors' questions. And the judge rules on those objections before and all their questions were asked. They were obviously relevant. That does speak for them paying close attention. But here we go. Let me be quiet so we can hear what's going on here. And of course, as soon as I say that, nothing's going on here. We've got a different person sitting behind the defense table today. Likely a different reporter. The jurors are now coming in, and the judge definitely doesn't want to keep them waiting in the courtroom. So we are definitely going to be beginning here fairly soon.
Okay, good morning, ladies and gentlemen. Does the state stipulate to the presence of the panel?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Okay, at this time, ladies and gentlemen, I am going to instruct you on the law. Officer Hawks is handing out the jury instructions. Each of you will have a copy of the instructions. You'll be able to take them with you when you go back to deliberate upon your verdict.
So she's going to likely read these jury instructions into the record so that the record has them. That means we are going to know what the jury instructions are.
To instruct you in the law that applies to this case, is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. Instruction number 2, if in the...
That is not actually the case. There is a thing called jury nullification, and if you don't know what that is, look it up.
These instructions, any rule, direction, ideas repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. Number 3, an indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of his guilt. In this case, it is charged an indictment that on or about the 2nd day of September 2022 within the County of Clark, State of Nevada, contrary to the form, force, and effect of statutes in such cases made and provided, and against the peace and dignity of the state of Nevada, the defendant committed the crime of murder with use of a deadly weapon, victim 60 years of age or older, as follows: did willfully, unlawfully with malice aforethought killed Jeffrey Gearman, who was 60 years of age or older, with use of a deadly weapon, to wit, a knife, by stabbing the said Jeffrey Gearman multiple times about the body, the said killing having been 1, willful, deliberate, and premeditated, and or 2, perpetrated by lying in wait for the said Jeffrey Gearman, and or 3, perpetrated by abuse of an older person. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case and determine whether or not the defendant is guilty of the offense charged. Number 4, murder is the unlawful killing of a human being with malice aforethought, either express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. Number 5, malice aforethought means the intentional doing of a wrongful act without legal cause or excuse, or what the law considers adequate provocation. The condition of mind described as malice aforethought may arise from anger, hatred, revenge, or from particular ill will, spite, or grudge toward the person killed. It may also arise from an unjustifiable or unlawful motive or purpose to injure another, proceeding from a heart fatally bent on mischief, or with reckless disregard of consequences and social duty. Malice aforethought does not imply deliberation or the lapse of any considerable time between the malicious intention to injure another and the actual execution of the intent, but denotes an unlawful purpose and design as opposed to accident and mischance. Number 6, express malice is that deliberate intention unlawfully to take away the life of a human being which is manifested by external circumstances capable of proof. Malice may be implied when no considerable provocation appears, or when all of the circumstances of the killing show an abandoned and malignant heart. Number 7, the indictment alleges alternative theories of murder of the first degree, as allowed by law. In addition to willful, deliberate, premeditated murder, the indictment alleges the defendant committed the murder by means of lying in wait and or by abuse of an older person. Number 8, one theory of murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. All 3 elements, willfulness, deliberation, and premeditation, must be proven beyond a reasonable doubt before an accused can be convicted of first-degree murder under the theory of liability. Number 9, willfulness is the intention to kill. There need be no appreciable space of time between formation of the intent to kill and the act of killing. Number 10, deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of the actions. A deliberate determination may be arrived at in a short period of time, but in all cases, the determination must not be formed in passion, or if formed in passion, it must be carried out after there has been time for the passion to subside and deliberation to occur. A mere unconsidered and rash impulse is not deliberate, even though it includes the intent to kill. Number 11, premeditation is a design, a determination to kill, distinctly formed in the mind by the time of the killing. Premeditation need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. For if the jury believes from the evidence that the act constituting the killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows the premeditation, it is premeditated. Number 12, the law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. The true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the first degree. Number 13, another theory of murder of the first degree is murder perpetrated by means of lying in wait. The elements necessary to constitute lying in wait are watching, waiting, and concealment from the person killed with the intention of inflicting serious bodily injury upon such person or of killing such person. Nothing requires that the lying in wait exist for or consume any particular period of time before the act which causes the death. It is only necessary that the act causing death be preceded by and the outgrowth of lying in wait. Where a killing is accomplished after lying in wait, the state is not required to prove premeditation or deliberation. The killing constitutes murder of the first degree so long as it was committed with malice either express or implied. Number 14, another theory of murder of the first degree is a kind of murder which carries with it conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of abuse of an older person. Therefore, a killing which is committed in the perpetration or attempted perpetration of abuse of an older person is deemed to be murder of the first degree, whether the killing was intentional or unintentional or accidental. This is called the felony murder rule. The intent to perpetrate or attempt to perpetrate abuse of an older person must be proven beyond a reasonable doubt. Number 15, any person who abuses an older person is guilty of abuse of an older person. Abuse means willfully causing unjustifiably pain or injury or mental suffering to an older person. An older person is defined in Nevada as 60 years of age or older. Number 16, although your verdict must be unanimous as to the charge, you do not have to agree on the theory of guilt or liability. Therefore, even if you cannot agree on whether the facts establish the defendant is guilty of willful, deliberate, and premeditated murder, murder by means of lying in wait, or felony murder by means of abuse of an older person, so long as all of you agree that the evidence establishes the defendant's guilt of murder in the first degree, your verdict shall be murder of the first degree. Number 17, all murder which is not murder of the first degree is murder of the second degree. Murder of the second degree is murder with malice aforethought, but without the admixture of premeditation and deliberation, nor by means of lying in wait or by means of elder abuse. Number 18, you are instructed that if you find the state is established that the defendant has committed first-degree murder, you shall select first-degree murder as your verdict. The crime of first-degree murder includes the crime of second-degree murder. You may find the defendant guilty of second-degree murder if, 1, you have not found beyond a reasonable doubt that the defendant is guilty of murder of the first degree, and 2, all 12 of you are convinced beyond a reasonable doubt the defendant is guilty of the crime of second-degree murder. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether such murder was of the first or of the second degree, you must give the defendant the benefit of that doubt and return a verdict of murder of the second degree. Number 19, you are instructed that if you find the defendant guilty of first or second degree murder, you must also determine whether or not a deadly weapon was used in the commission of the crime. If you find beyond a reasonable doubt that a deadly weapon was used in the commission of such an offense, then you shall return the appropriate guilty verdict reflecting with use of a deadly weapon. If, however, you find that a deadly weapon was not used in the commission of such an offense, but you find that it was committed, then you shall return the appropriate guilty verdict reflecting that a deadly weapon was not used. Number 20, deadly weapon means any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing substantial bodily harm or death. 21, the state is not required to have recovered the deadly weapon used in an alleged crime or to produce the deadly weapon in court at trial to establish that a deadly weapon was used in the commission of the crime. Number 22, in arriving at your verdict in this case as to whether the defendant is guilty or not guilty, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. If your verdict is murder of the first degree, you will, at a later hearing, determine the issue of penalty or punishment. Number 23, to constitute the crime charged, there must exist a union or joint operation of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charged, and the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. Number 24, the defendant is presumed innocent until the contrary is proved. This presumption places upon the state of Nevada the burden of proving beyond a reasonable doubt every element of the crime charged and that the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life if the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, he is entitled to a verdict of not guilty. Number 25, the evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all of the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorney stipulate to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuations suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Number 26, in this trial, you heard evidence of other acts regarding the defendant, Mr. Tejas, in the articles written by Jeff Gehrman. You are not to conclude from this evidence the defendant is a person of bad character or is predisposed to commit crimes. Number 27, the credibility or believability of a witness should be determined by their manner upon the stand, their relationship to the parties, their fears, motives, interests, or feelings, their opportunity to have observed the matter to which they testified, the reasonableness of their statements, and the strength or weakness of their recollections. If you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of their testimony which is not proved by other evidence. Number 28, witnesses who have special knowledge, skill, experience, training, or education in a particular subject have testified to certain opinions. This type of witness is referred to as an expert witness. In determining what weight to give an opinion expressed by an expert witness, you should consider the qualifications and believability of the witness, the facts or materials upon which the opinion is based, and the reasons for each opinion. Opinion is only as good as the facts and reasons on which it is based. If you find that any fact has not been proven or has been disproved, you may consider that in determining the value of the opinion. Likewise, you must consider the strength or weaknesses of the reasons on which it is based. You are not bound by any opinion. Give each opinion the weight you find it deserves. You may disregard any opinion if you find it to be unreasonable. Number 29, although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Number 30, during your deliberations, you're not to communicate with anyone in any manner regarding the facts and circumstances of this case or its merits, either by phone, email, text, messaging, internet, or other means. You are admonished not to read, watch, or listen to any news or media accounts or commentary about the case. You're not permitted to do any independent research, such as consulting dictionaries, using the internet, or any other reference materials. You are further admonished not to conduct any investigation, test a theory of the case, recreate any aspects of the case, or in any other manner investigate or learn about the case on your own. Number 31, when you retire to consider your verdict, you must first select one of your members to act as foreperson who will preside over your deliberation and will be your spokesperson in court. During your deliberation, you will have all the exhibits admitted into evidence, these written instructions, and forms of verdict prepared for your convenience. Your verdict must be unanimous. As soon as you agree upon a verdict, the foreperson shall sign and date the verdict form and return with it to this room. Number 32. Now you will listen to the arguments of counsel, who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, You will bear in mind it is your duty to be governed in your deliberation by the evidence as you understand it and remember it to be, and by the laws given to you in these instructions, with the sole fixed and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. The state may open and close the arguments.
Thank you, Your Honor.
Does anybody have any questions about those instructions?
By June of 2022, Jeff German had caused a lot of problems for the public administrator, Robert Tellis. He had written articles accusing Mr. Tellis of an inappropriate relationship. He had written that he was bullying in the office and had created a hostile environment in the public administrator's office. He had written an article saying that the management of Mr. Tellis was so bad that the county had to bring in a private consultant in order to assist with the management of an 8-person office. After Mr. German wrote those articles, Mr. Tellis lost his primary race and would not be the public administrator after that. And not just that he lost the race, he lost the race to a rival within the public administrator's office itself. And from the text messages of Mr. Tellis, we learned that this was deeply, deeply troubling for him. He wrote to Mr. German, "I don't know what to say. I told you how much this all impacted me. You heard from employees who are being harassed by these people, provided you," I think this is a typo, "proof that I was doing my best to actually smooth things over. I had to make hard decisions. Still, you wrote an article that makes it sound like I'm the guilty one. That wasn't fair or balanced." He told Mr. German, "I'm distraught right now. Clearly there are typos in my message." He told Mr. German that he was adding to the pressure of his life. "I've done so much for that office. I've told you that I've been followed and that I caught Rita following me. You decided to take it on her word that she wasn't. However, clearly she was. It seems to me that you valued sensationalism or the value of a potential takedown than actually telling the truth. Thank you for helping him drop more pressure on my life." Now, Mr. German's response was a response that you get probably from many reporters. He says, "Sorry you feel that way. My editors and I feel the story is fair and balanced." Mr. Tellis's response, "I don't know that you could truly feel that. You have concrete proof I provided you of what is really going on. You acknowledge much of it. You mention none of it. If telling yourself that you were fair helps you sleep at night while you're trying to destroy good people, that's your prerogative." And Mr. Tellis does attempt to fight back from these articles. On his campaign website, he posts this letter discrediting the paper and discrediting the allegations in those articles written by Mr. German. He goes on Twitter and he accuses Mr. German of being a bully. He says Mr. German had threatened him. He told other people on social media in this first screenshot that because of those articles, I had to increase my medication to cope with it all. He tells someone who reposted the article or sent it that he was deeply disappointed that they had done that. And he's generally following the fallout of those articles on social media. But the reality is he lost that primary election after those articles were written, and he attributed it to the articles written by Jeff German. He told his best employee, Nicole Lofton, unfortunately, too many people bought the lies. He told his best employee, Nicole Lofton, "I'm so sorry. I'm devastated that everything we worked for is going to be done. I hate them and what they did." And after all that happened and losing the primary, his concern was that another article might be coming. He explains, "I'm going to pull the trigger on the supervisory changes. I'm going to go with the original plan. I think if I do any more than that, they will say I'm interfering with operations." And then he added, "She is probably trying to get fodder to pass to the reporter." And he sent another text after that there's more garbage being gathered for a news article. And Mr. Tellis testified to you that after the primary took place, he actually half drafted, he didn't file it, a lawsuit where he was going to sue his rival, Rita Reed, and he was going to insinuate in that lawsuit, coincidentally, that there was a conspiracy that caused his problems in the election. If you look at point 21, he wrote, upon information and belief, several employees conspired to make false allegations of mistreatment by Mr. Tellis. These employees contacted the Las Vegas Review-Journal to share false and defamatory statements in support of news articles against Mr. Tellis. So he was clearly incredibly upset that those articles were written and that it resulted in him losing that primary. In July, Jeff German, though, isn't done with his stories and his examination of what is going on with Mr. Tellis and the public administrator's office. In July, he sends that request for the public records of the county, where he's asking for communication between Mr. Tellis and Roberta, and then ultimately it expands to other individuals in the county. But he wants all team messages between Mr. Tellis and Roberta. He wants cell phone messages. He wants essentially all of their communications as of July, and that's after those 4 articles were written. Mr. Tellis, of course, is informed by this, informed of this request by the county, and this occurs on August the 8th, and they explain, hey, look, this reporter's seeking all of this information. So the message underlying all of this is another article is forthcoming. Mr. Tellis messages back that he wants to review those communications prior to them being released to the reporter. But as of August 8th, he's on notice of another article coming. And if you look at this email, he responds about 20 minutes after that first email was sent to him. Now, looking at the August calendar, you can see that on August the 8th, that's when he receives the notification of the public records request. And by August the 12th, there are images from Google Maps of Jeff German's neighborhood, Bronze Circle. We don't know the date they were created, but we know they were modified by August the 13th, meaning they had to be created sometime before that. Now, this doesn't mean that Mr. Tellis physically went to Bronze Circle on the days leading up to the modification date of the 13th. It simply means that he went and accessed Google Maps, and Bronze Circle is the area that was searched and accessed by his phone. And those images are, of course, where Jeff German lives. Now, the next date to keep in mind in our series of events in August of 22 is August the 15th. In August the 15th, that is when there's images of all of those cars that are kind of driving along the access road to Jeff German's neighborhood. Now, once again, we have a modification date. That doesn't mean that the images were all taken on the 15th, but they had to exist before the 15th to be modified on that date. And if you recall, Detective Gaddis figured out where this was, and it's right off of Mr. German's neighborhood. His house is right here on Bronze Circle, and she figured out by looking at the photographs where it was located in Las Vegas. And she figured out it was located right at this Popeyes parking lot, and that slanted wall ends up being in almost all of the images. And there are a lot of them, of several cars driving by the access road to Mr. German's house. So we have the notification on the 8th, we have accessing Google Maps on the 12th, we have those screenshots of all of those vehicles in conjunction with Mr. German's neighborhood by the 15th, and then by the 23rd, there have been searches of Mr. German's personal information on Mr. Tellis's computer. This is Mr. Tellis's work computer at his desk. If you look at the screen on the right, you can see like there's a bottle of hand sanitizer, kind of there's an arrow pointing to it. Here's a closer view. And the screenshots from his phone, you can see that the same cap to that bottle is in the screenshot as well. So these were clearly taken on his work computer while he was at work. And you can see that he's looking up personal information of Mr. Gehrman, the kind of car he drives. He ultimately is able to get the address of 7216 off his work computer. And once again, those photos were in existence by August the 23rd of 2022. So all of those events, the notification, the accessing of Bronze Circle on Google Maps, the screenshots of the car, and then using the work computer to access personal information of Jeff Gehrman all occurs in August of 2022. Moving to September, that's when Mr. Tellis, on September the 1st, receives notification that the county is getting ready to release all of those documents that were subject to the public records request. He's notified, and Ms. Kennan is notified on September the 1st of 2022, and the murder's the very next day. It's about 15 hours later. Now we know that on the morning of the 2nd, Mr. Tellis left his house and proceeded into the area of Mr. Gehrman's neighborhood, and that he kind of meanders around there, but ultimately ends up on those cross streets and then proceeds on foot to Mr. Gehrman's residence. Mr. Tellis's residence is at the top of the screen there on Spanish Steps. He goes down that Silk Tassel Road and then goes on Red Hills Road. And he leaves at 9:12 in the morning. Now, eventually, he's in the area of Rock Springs Drive, which is near Mr. Gehrman's neighborhood. The time on that video is incorrect. It says 9:42 a.m. But you heard from Detective Mogg that the corrected time for that particular camera is 10:26. So he's in the area of Mr. Gehrman's neighborhood at about 10:26 a.m. in the morning. What's the next thing that happens? Well, you know that this is Mrs. Tellis's Apple Watch, and she sends that message to Mr. Tellis at 10:35 a.m. You can kind of see it says Friday 10:35 a.m. And the message is, where are you? Well, he's sitting in Mr. Gehrman's neighborhood, so he's not answering this text message. That text message goes unanswered. Mr. Tellis at 10:40 a.m. is now on Wintergreen Drive, which is the cross street to Bronze Circle. He's on Wintergreen Drive at about 11 a.m. and the murder itself takes place at about 11:18 a.m. Then Mr. Tellis is back at his own neighborhood by 11:51 a.m. And this is video from that Piggott Elementary School, which Detective Mogg indicated that that timestamp is correct. And what does he do? He gets back at 11:51 a.m. and then he's able to get his BMW and proceed to Planet Fitness. So there's his BMW leaving. It's 12:03, and then you know from Detective Gaddis's testimony that it's about a 4 to 6 minute drive. He's able to be at Planet Fitness by 12:09. So by 9/3, which is now the day after the murder, it has been reported that Jeff Gehrman has been murdered. And then Roberta, who's working, has heard about the murder, and she's starting to get concerned. She tells Mr. Tellis, I'm working tomorrow now. I don't want to be in the office alone. I'd rather be with the crazy women than alone right now. She's concerned about Mr. Gehrman getting murdered, and she's scared about being in the office alone. By September 5th and 6th, the Las Vegas Metropolitan Police Department has released images of the assailant and also of the Yukon itself. And Roberta becomes even more concerned. She messages Mr. Tellis, Rob, WTF, please do not be driving your Yukon around for a while. This is on September the 6th. He answers, whoa, that's crazy. She says, please tell me your Yukon is not that color. He answers, it is similar, if not the same. She says, I'm freaking out, Rob. He answers, my car has all matching wheel patterns. I think they are saying that there's a difference between the front and the back of the assailant's vehicle. But Roberta looks at it and says, fuck, your car is identical. And it actually turns out that Roberta is the one that is correct. His car is identical. From that lighter spot on the passenger side, just below the windshield wiper, there's sort of like a lighter rectangular shaped portion of the car. You can see that in the video. From the differentiating tint between the front and the back of the vehicle, that part is identical. And from the wheels themselves, they weren't different. They were the same. The wheel rims on the front and the back are identical. It is his Yukon. He is the one who committed the murder. So let's talk about the charge of murder. Murder is the unlawful killing of a human being with malice aforethought, either express or implied. And all that means is an act of ill will. When you go back to deliberate, you'll be asked two overarching general questions about the crime. And those are, was a deadly weapon used in the commission of the crime? And was the victim of the crime 60 years of age or older? So as you heard from Judge Levitt, a deadly weapon is simply an object capable of causing substantial bodily harm or death. We obviously have that in this case. The knife wounds inflicted on Mr. Gehrman were definitely not caused by human hands, and they were capable of causing substantial bodily harm or death, because that's ultimately what happened. You may be asking, well, where is it? Like that knife didn't come to court. But the instructions tell you that the state is not required to have recovered a deadly weapon used in an alleged crime or to produce it at trial. You just have to be able to gather from the evidence that a deadly weapon was used. Obviously, the injuries of Mr. Gehrman indicate that this was not caused by human hands. A deadly weapon was used to accomplish his murder. So that overarching question about the crime is probably an easy one to answer. Probably the easiest one after that is, was Mr. Gehrman over 60 years old at the time the crime occurred? And he was 69 years old at the time it occurred. So let's talk about first-degree murder. As Judge Levitt explained to you, there are three theories, three pathways that you can reach a verdict of first-degree murder. The first one is a willful, deliberate, and premeditated murder. The second one is murder perpetrated by means of lying in wait. And the third one is murder perpetrated during the course of elder abuse. Now, the first form of first-degree murder is probably the one you're the most familiar with, and that is a murder that is willful, deliberate, and premeditated. And you'd have to find all of those elements in order to find Mr. Tellis guilty under that theory of first-degree murder. So let's talk about what each of these mean. Willfulness is very simple. It's simply an intent to kill. Do your actions demonstrate an intent to kill? So this part of the video takes about 2 minutes. The entire time of that 2 minutes, Mr. Tellis is attacking Mr. Garriman with a weapon. So that demonstrates an intent to kill. He's stabbing him repeatedly. Mr. Garriman is clearly trying to fight back, but Mr. Tellis doesn't stop. It keeps going and going and going. And it's kind of a long time to be inflicting injuries on another individual. He finally walks out on the side. But the duration of that time, the entire time, Mr. Garriman is being attacked. So let's talk about deliberation, which is the second element. Deliberation is determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action. Well, what do we know about Mr. Tellis's actions prior to the murder? Well, we know back in August, when he got notification that another story was likely coming, he kind of goes into research mode on Mr. Garriman, where he's located, what kind of car he might be driving, searches on his computer. All of that demonstrates deliberation. Even if you didn't have all of these actions back in August, the length of time of the actual attack itself is sort of a shorter version demonstrating a course of action to kill, right? In the course of 2 minutes, you are stabbing someone multiple times, you could change your mind, but he doesn't do that. He keeps going and going and going, not even withstanding all this pre-planning. Now, premeditation is the last element of that first theory of first-degree murder, and that is simply a decision to kill before you do it. Before you came in and sat as jurors, you may have thought that premeditation is always a case of pre-planning and months in advance and that sort of thing. And that is definitely a case of first-degree murder and kind of exactly what we have in this case. But you're told by the instruction that premeditation need not be for a day, an hour, or even a minute. It can be as instantaneous as successive thoughts of the mind. So what that instruction tells you is, in the law of Nevada, for premeditation, if I make a decision to kill you and I do it a month from now, that's premeditation. If I make a decision to kill and I do it a week from now, that's premeditation. If I do it an hour later, it's premeditation. If I do it a minute later, it's premeditation. If I do it a second later, it's still premeditation. And you have a video of the attack on Mr. Garriman, and clearly there's a decision made to kill him. But beyond that, you also know that Mr. Tellis took the step of leaving his phone at home prior to the murder. That's indication of premeditation and planning. You know that he bothered to disguise himself by wearing the hat and the orange outfit. That shows premeditation, a decision to kill. And you also know, most of all, that he brought a weapon over to Mr. Garriman's house, and that shows premeditation as well. So that theory of first-degree murder has been established in this case. Let's talk about the second theory of first-degree murder, which is murder perpetrated by means of lying in wait. And the instructions explain what that is. Another theory of first-degree murder is murder perpetrated by means of lying in wait. And what that is kind of taking on a place of concealment in order to inflict injury or death upon another person. It's sort of the second paragraph. It says, watching, waiting, and concealment from the person killed with the intention of inflicting serious bodily harm upon, or serious bodily injury upon such person, or of killing such a person. And in this case, you actually see the actions of Mr. Tellis literally lying in wait. He goes into Mr. Garriman's yard and recedes to the back in order to be in a place of concealment in order to attack him later on. And that is literally lying in wait. So that theory of first-degree murder is established as well. The third theory of first-degree murder is murder occurring during the perpetration of abuse of an older person. And this is kind of like child abuse, where if you abuse a child and a child happens to die in the course of abuse, it's automatically first-degree murder. The same is true for individuals who are over 60. If you abuse an older person and they die during the course of that abuse, that is an automatic case of first-degree murder. And it's sort of a policy judgment to protect vulnerable members of our society. The instructions tell you another theory of first-degree murder is a kind of murder which carries with it conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of abuse of an older person. Therefore, a killing which is committed in the perpetration or attempted perpetration of an older person is deemed to be murder of the first degree, whether the killing was intentional, unintentional, or accidental. We have that in this case. Mr. Gehrman was over 60 years old, so by abusing him and causing his death, it is automatically another theory of first-degree murder. So this is a picture of the verdict form that you'll have back in your deliberation room, and you can kind of see on the top in all caps it says murder with use of a deadly weapon, victim 60 years of age or older. That was those very first two questions I discussed with you at the beginning of the closing that you would answer as jurors. And then as a jury, you should ask about the individual theories of first-degree murder and vote on them. So you have to vote if all 12 of you think that this was a willful, deliberate, and premeditated murder. Do all 12 of you find that it was perpetrated by means of lying in wait? Do all 12 of you agree that it was perpetrated in the course of abuse of an older person? If you find all of those, then you mark those boxes. If you are in disagreement, say only 3 of you think it was willful, deliberate, and premeditated, or some combination, you have to take a vote to decide if all of you believe that it's first-degree murder under some theory. And if it is, you mark that last box and say, we don't find unanimously under any of those 3 theories, but all of us agree, 12 of us agree that it's some form of first-degree murder. The law tells you, although your verdict must be unanimous as to charge, you do not have to agree on a theory of guilt or liability. So if all 12 of you agree one form of first-degree murder, then you mark that last box. But it's the state's position that all 3 of those theories, willful, deliberate, premeditated, lying in wait, and elder abuse, clearly apply in this case.
So I just want to pause briefly. The reason that she wants them to check all 3 boxes is because the defendant still has an opportunity to appeal. If the defendant appeals and they've checked the box that says we couldn't agree on the theory under which this first-degree murder was committed, but we think it was first-degree murder, well, then the defense has more things to attack. So they can attack whether or not this person was the correct age, or whether or not a deadly weapon was used, or whether or not this was premeditated, because essentially one juror could have voted that it was premeditated but didn't think that it was lying in wait or elder abuse, in which case if the defense just attacks the proofs as to one of the 3, then they can possibly get the verdict overturned. If the jury checks all 3 boxes for each of the theories of first-degree murder, then the defense has an extremely uphill battle, because they have to disprove the prerequisites for each of those theories. They basically have to attack the evidence that points to each of those separate theories of first-degree murder.
And really, Mr. Tellis isn't disagreeing that this is a case of first-degree murder. He's just saying that it was a Compass Realty assassin who did it. Now here we see Mr. Tellis leaving his house at about 9:12 a.m. And it's the state's theory, of course, that at that point he's left his house and his cell phone is sitting back at his house on Spanish Steps. The state's theory is that Mr. Tellis leaves his residence, leaves the phone at the residence, and is proceeding to Mr. Garriman's residence. And as we've discussed, the Yukon is seen at Rock Springs at about 10:26 a.m. Here's two different images of it. Meanwhile, Mr. Tellis's cell phone, which is sitting back at Spanish Steps, is getting some incoming messages. There's an incoming and unanswered message at about 9:44 a.m. about a work case. There's an incoming and unanswered message at about 10:16 about another case at his work. There's an incoming unanswered message from his wife saying, "Where are you?" at 10:36 a.m. Now you'd think, given that some of the allegations in the articles, this might be one he'd answer pretty quickly. There's an unanswered incoming call from his wife at 10:43 a.m. that doesn't get answered by him. And there's another incoming call that occurs at 11:16 a.m. Meanwhile, he is at Mr. Garriman's house. So ask yourself this: if this was really a Compass Realty assassin who was committing the murder at Bronze Circle, how would that individual know that Mr. Tellis, with his phone at his house, wouldn't have answered a call, or wouldn't have gotten in another text string, or wouldn't have made a call himself? How could anybody but Mr. Tellis be the killer? No one would have that level of assurance, because if any of those calls had been answered from his house, it would be clear that he wasn't the one involved. Now we know from the video evidence from Bronze Circle that after the murder occurs, Mr. Tellis actually returns to Mr. Garriman's house, and he goes to the side area of the yard where Mr. Garriman is located. And then he returns back to the Yukon. And eventually does that U-turn and drives away. But if you're wondering why there isn't blood in the Yukon, he had to walk all the way out of that crime scene, and anything that had been deposited on his shoes would have come off in the rocks. Besides that, the crime scene itself is not drenched in blood on the ground. These are Mr. Garriman's shoes. There is some blood on them, but they're not exactly drenched, and he's the victim. So after Mr. Tellis leaves Bronze Circle for the second time, he goes east, he goes on Wintergreen, he goes on Washington, he goes on Rampart, he goes on Apple, and he goes back to his neighborhood at 11:51, and then he leaves again to go to Planet Fitness at about 12:03. You also know that Mr. Tellis is the killer because of the DNA evidence in this case. Remember how this comes into play. They collect the samples from the scene, and the Metro DNA analyst has this result of foreign DNA being present on September the 5th. They haven't even collected a DNA sample from Mr. Tellis until the 7th. So it's not like Metro or Compass Realty has a sample of Mr. Tellis's DNA to come insert in this crime scene. It's Mr. Tellis's DNA in this scene. It's literally on the body of Mr. Garriman. The items from the search warrant also tell you that Mr. Tellis is the person responsible for this crime. Those shoes that were found in the house, they weren't planted, they were hidden. They were cut up. Anyone who planted the shoes would have no reason to cut them up. The cutting up is to benefit Mr. Tellis so he can get rid of them. If you were just planting them, you could leave them alone. And they're clearly his shoes because one, they're in his house. Two, his DNA is present on them. And if you don't believe that, there's pictures in his phone of those shoes on a day when he apparently went rock climbing. You have the bag that was located and ultimately the hat as well. And you heard a lot of testimony about how all of this evidence was collected from the scene. There's the detective who physically finds it, working with other detectives who are also doing the search. There's the detective that's assigned to be the scribe, to write down where everything is located. There's a crime scene analyst assigned to photograph it in place. There's DNA analysts who actually analyze the physical evidence after the fact. And all of this occurred, this whole search occurred while his wife is sitting in the house and aware of what they're doing. None of this evidence was planted. There's the bag, there's the hat, that was the location of the hat in his house. Finally, you know from the searches, the Bronze Circle where he accessed the Google Maps, Mr. Gehrman's house, that he is the one responsible. He's not friends with Mr. Gehrman. He doesn't have business to do with Mr. Gehrman. There is no reason for images of Bronze Circle to be in his phone prior to the murder occurring. You also know that he is the one responsible from the sort of amateur surveillance that occurred in August prior to the murder itself. There's no reason for any of this to be in his phone, but that he's attempting to gather information on Mr. Gehrman. And finally, you know he actually used his work computer to gather information on Mr. Gehrman as well. At the end of his testimony, I think yesterday, Mr. Tellis explained that he's really a victim in this. He's been victimized by the whole process. And he told you that he was wronged by his coworkers who didn't appreciate his changes that he made in the office and didn't appreciate his management style. He was wronged by the county who didn't understand that he was being a good leader. He was wronged by Zach Schilling, and by Kristen Riffle. He was wronged by them as well. He was certainly wronged, according to him, by Compass Realty. He was wronged by Steve Wolfson. He was wronged by the patrol officers who preserved that scene at Mr. Gehrman's house. He was wronged by Metro Police, in particular, Detective Gaddis and Detective Jappy. He was wronged by some mysterious, illusory phone hacker. He was wronged by DNA analysts at Metro who found his DNA on the fingernails of Mr. Gehrman. And then, of course, he was obviously wronged by Mr. Gehrman, too, in the articles he wrote. Or maybe it's not that he was wronged. Maybe he's the one in the wrong.
Thank you very much. At this time, we're going to take a 10-minute recess. During this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media, or read, watch, or listen to any news or media accounts or commentary, do research, consult dictionaries, the internet, or reference materials, do any investigation, test a theory, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case until it's finally submitted to you. We'll be in recess for 10 minutes.
Thank you. All rise. The next be heard, please, jurors.
So there we go. There's the beginning of the prosecution's closing argument. So they are going to get a chance to go again. They both sides get an equal amount of time to give their closing arguments, but the prosecution has reserved a portion of their time to go at the end and kind of refute anything that the defense may say during their closing argument. So now we have pretty much heard everything that the prosecution has on Tellus. And I don't know that it was the best delivery, especially the piece at the end with respect to Tellus being the victim here. But Allison, thanks for the subscription. We greatly appreciate it. Especially the piece where she was saying that Tellus is the victim here. I think that could have had a stronger delivery. But all in all, they hit all the points that they needed to hit. And I think one of the biggest points that they hit was when she went through the timeline of that day, when we see that red Yukon, that maroon Yukon traveling throughout the community. And, you know, she points out the times that the text messages came. And then she points out the time that he allegedly arrives at Planet Fitness. She ties all of that together to demonstrate, look, even with his supposed exculpatory evidence of him having been at Planet Fitness that day, it fits with the timeline. He says he showed up at 12:03. Well, he was back in his neighborhood at 11:51. The murder was committed at 11:18. All of this fits with the timeline of events. So that exculpatory evidence is no longer exculpatory. The prosecution in this case is able to say, tell us, as opposed to saying, you know, the assailant, as opposed to using the word allegedly. They're putting on their theory of the case so everyone knows that all of this is allegedly until the jury comes back and says, determines whether this particular person is guilty or not guilty. All of this is allegedly. So she's able to go in and say, Tellus did this at this time. Tellus did that at that time, in order to paint in the juror's mind, in order to associate Tellus with this crime in as vivid a manner as possible. So she did a good job of pointing to the footage and saying, there's Tellus committing this crime. There's Tellus in the backyard lying in wait. Not saying there's the assailant. There's, you know, the suspect. There's this. It's Tellus. She's telling the jury, this is Tellus. And all of this evidence points to it being Tellus. And all you're left with is his supposed conspiracy theory. And that's essentially what we said in the beginning. All we're left with is his alleged conspiracy theory. That's it. Any potential evidence that he has put on has been eviscerated from, you know, his saying this stuff doesn't belong to me. She shows the picture in his phone of the shoes. This DNA should have been in the vehicle. Well, one, Mr. Gehrman didn't have very much blood on his shoes, and he was traipsing through the garden and likely wiped off any DNA that may have been there, but the crime scene was never drenched in blood and DNA in the first place. So she did an admirable job of piecing everything together, and I think that the thing that is going to stick most notably in the jury's mind is that timeline. They were likely taking notes, writing down exactly what she was saying with respect to the timeline. The judge in this case is the only person who can tell the jury what the law is. Before they get here, before we get to this point, the defense and the prosecution meet. They go over potential jury instructions. They kind of come to a consensus on what the jury instructions should say. And there's always going to be some disputes. They go before the judge and says, here's what we agree on and here's what we don't agree on. And the judge says, okay, this is what we're going to do. Everybody okay with that? You're not okay with it? Okay, appeal it. And that's how we get to those jury instructions. But once those jury instructions are written, once they're done, once the judge signs off on them, that is the law in this case. That's the only law the jury is allowed to hear. So when you saw her putting up the actual jury instructions, she's doing that for two reasons. One, the jury is going to have a copy of those instructions and she wants to point certain language out in those instructions. And two, because she can't deviate from those instructions when she's telling the jury what the law is. If she deviates from that, then the defense attorney can object. If that objection is not sustained and the jury isn't given a limiting instruction, an instruction that advises them, you cannot pay attention to what she just said, only pay attention to the instructions as I've given them to you, then that's grounds for an appeal. That's grounds for a mistrial. So she was very careful to stick to what the instruction said. And in all of these cases, criminal, civil alike, displaying for the jury, this is what your jury verdict form should look like when you get all done. Showing that to the jury so they know exactly what they're being tasked with by the prosecution. What do we need to put to make sure this guy goes to jail for the rest of his life? Of these things, okay, great. We're going to go give you those things. That's what she's trying to do, and she did that well. Ms. Carroll says, I think the other attorney would have done a better job. Yeah, DA Hamner has been excellent throughout this trial, and he's, in my opinion, he's a much more impactful speaker. And I think he would have done a better job of framing this in a way that the jury would find memorable. Hers was very factual. Her rendition was very factual in nature. It gave them everything that they needed, but it didn't have the same gravitas that I think a DA Hamner would have been able to bring to it. And so it's, other than, the notes that they've taken regarding the facts, I don't think that they're going to go into the jury room and kind of and have an epiphany, where they're remembering everything that the district attorney said, because what she said is kind of not. It wasn't strong. The telling of it wasn't strong. The facts were strong. The telling wasn't very strong. Yeah, and Natalie says DA Hamner was not playing up there. I would have preferred to see him give the closing statement. Yeah, so I agree with that point, but I do think that she did an admirable job, and I think that she did everything that she needed to do while she was up there. The first thing that stood out that she did was she explained to everybody, look, this is an 8-person public administrator office. 8 people. That's including Tellus. And yet that 8-people department had to have an independent manager come in because the elected public administrator obviously can't handle the office politics or whatever's going on in that office, can't manage that office adequately. And that came out in Gehrman's articles. And I hadn't realized, I guess I just hadn't made the connection. There's only 8 people here. You can't manage 8 people. They're paying you a lot of money to be the Clark County public administrator, and you can't manage 7 people and yourself. That has to look bad. And up to that point, I had just been thinking about, the alleged hostile working environment, and just been thinking about the alleged extramarital affair. At that point, alleged. It's no longer alleged, but this extramarital affair, and thinking those were the things that were hurtful to Tellus. But remember, at the end, Tellus said in one of the text messages that this likely ruined his job prospects moving forward. Well, the fact that he can't manage a 8-person office likely went a long way to ruining his job prospects. And he is likely placing that at the feet of Jeff Gehrman. He's likely blaming Jeff Gehrman for that because outside of Jeff Gehrman, everything that everybody in the office was trying to do to remedy the situation in the office and bring light to the situation in the office wasn't working until they contacted one Jeff Gehrman. And when he got involved, everything in that office blew up. So I think that was a very strong point and likely one that the jury honed in on. If they didn't, they should have. The timeline that she gave, and she was very careful not to say that this is when he was doing certain things. Very careful not to say this is when he was searching these Google images, and this is when he took the images of the vehicles. She was very careful to align it with what the evidence actually showed, and that's that these things existed in his phone as of a certain date, meaning that they happened on that date or before. But the way that she kind of put it together with respect to when he found out that Jeff Gehrman was still investigating him, and then these Google images of Gehrman's house are on his phone on the 12th or before. The images of these vehicles, this, surveillance of these vehicles driving down this street are on his phone as of August 15th or before. The searches of Gehrman's personal information regarding his vehicle happened on August 23rd or before. Kind of put everything in order, this entire investigation in order, so that you see it makes sense that he was looking up Gehrman's vehicle information after he took the surveillance footage of these cars traveling down this road, because he probably thought, all I got to do is look at the cars traveling down the road and I'll probably see Jeff Gehrman driving one of them and I'll be able to identify him that way. And that'll be the easiest, figure out what car he's driving. But when he was unable to identify Jeff Gehrman in a particular vehicle, well, then he resorted to looking up using county resources, the county server and the proprietary county software to look up Gehrman's information. And that's likely why he did it on his work computer as opposed to trying to find that information on his personal cell phone. And then when he got the notification that the public records request was going to be released on 9/1 and Gehrman was murdered on 9/2. And she went from, here's what happened on a day by day, week by week, day by day basis, to now let's go minute by minute. 9:12 a.m. he leaves his house. We see his car leaving. And it was kind of masterful. Just the way that timeline was put together. And then to recall Roberta Lee Kennett's testimony, even though the things that Roberta Lee Kennett was saying wasn't necessarily evidentiary in that, Roberta Lee Kennett is saying, your car is identical, but that's not the evidence that the car is identical. It's the cars are identical is the evidence of the cars being identical. We can look at them and see these two cars are identical, but still bringing Roberta Lee Kennett into it and reminding the jury of Roberta Lee Kennett's testimony, because remember, she's the one that said, Tellis told her that he hated Jeff Gehrman. So reminding them of her testimony was probably a good thing, because somebody on that jury pool wrote down and or remembers that she said Tellis hated Gehrman. So reminding them of that testimony, they're going to get back in the jury room, and whatever jurors remember that is going to remind everybody else, hey, look, this was his boo, and she said he hated her. So that was a pretty good thing. So all in all, pretty good closing statement. Wish it would have been DA Hamner giving it, but Still a very good one. Natalie says D.A. Hamner had me laughing when he told Tellus that he was wearing his little moccasins when he was washing. Right. So Tellus was trying to say, you all took surveillance footage of me in certain shoes on days when you said you didn't have surveillance footage. Looks like we're back. So yeah, I do recall that, Natalie, and that was kind of funny. But let's get back to what's going on in the court. Probably standing because the jury's probably coming in right now.
Thank you, everyone. Please be seated. Please come to order. Court is now back.
You're not supposed to sit down until you're told to sit down.
Does the state stipulate to the presence of the panel?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Mr. Fasbich, you may begin your closing argument.
Thank you. Am I on? Proof beyond a reasonable doubt. It's the highest standard in this country. It's not presumption, preponderance of the evidence. It's not clear and convincing. It's proof beyond a reasonable doubt. This concept was borrowed from the Old English common law. Our founding fathers thought that it'd be better to let it's better to let 10 guilty men go free than to wrongfully convict an innocent person. Additionally, I would submit to you that it reflects the reality that very few people have the resources, the means, the wherewithal to prove their innocence. You know, you heard testimony by narrative by the defendant, Mr. Tellus. Generally, you don't discuss a person being in custody, but he testified truthfully from the stand concerning his incarceration. He had testified that he'd been in custody for 2 years and that he wanted to tell you his story. Jury instruction number 27 discusses a witness's manner upon the stand. You and you alone are to judge every witness's credibility. In jury instruction number 3, it states that you are to apply the law to the facts. As we had stated at the beginning of this trial, you are the sole judges of the facts in this case. We had asked you at the beginning if you would keep an open mind, and we're certain that you have. This case is not about who called the most witnesses. The state did. This case is not about who had the most exhibits presented to you. The state did. We had asked you that at the close of evidence and at the end of this trial, if we were to sit at counsel table with Mr. Tellus and not ask a single question, not discuss a single document, not to submit a single document, if you had a doubt, and if it were a reasonable one, he'd be entitled to a verdict of not guilty. Let's talk for a minute what the state hasn't proven. And again, there is no burden whatsoever on that man. Jeff Garman DNA wasn't anywhere but at the scene of the crime. And this is significant because we heard a very able explanation of the state's evidence from their point of view. There was no blood or DNA evidence concerning Mr. Garman in Mr. Tellus's home, in or on his vehicles, in or on his clothing. None of that would implicate Mr. Tellus. There had been discussion on the state's closing wherein there was blood everywhere in this, in the bronze circle address. Obviously, it was a stabbing. You can see through the exhibits that you will have with you in the jury room. There was blood everywhere, on the bushes, on the bird dish. Nowhere in Mr. Tellus's vehicle do we find blood. You recall the testimony, blood presumptive negative, on both doors on the driver's side, the seat belt, the brake pedal, the gas pedal, the mat, nothing. There was no blood on his person, clothing, anything else. You didn't hear from any witnesses concerning any personal knowledge to contradict Mr. Tellis's version of the events for September 2nd. There was not a positive identification of the subject vehicle or Mr. Tellis at the scene. There's no evidence whatsoever of any gloves being recovered. And you've seen, and it's fairly clear from the video evidence that you've been presented, that assailant was wearing gloves. There was no recovery of a murder weapon. That vest with the reflective strips, you didn't see that. And the pants, I mean, we had pants that were recovered. You saw the blue pants. Obviously, that didn't bear any evidence to implicate Mr. Tellis. And I would submit to you that the facts and common sense would dictate that had he been the murderer, there'd be evidence of it on these articles, on that getup that that person was wearing on September 2nd. This is a point that I would urge you to consider, because I would submit to you that's crucial in determining whether the state, and again, it's the state alone that bears the burden, has proven their case against Mr. Tellis. There's no surveillance or eyewitness testimony showing that Tellis left his house that day headed to Mr. Gehrman's home. We did hear evidence, and it was uncontroverted, and that came through Detective Gaddis, that on the day of the stop, September 2nd, it's Metro policy to have body cam. The officers that stopped him in relation to the warrant that was obtained with Mr. Jappy's, Detective Jappy's participation, it was issued at 2 a.m. on the 7th. The officers that stopped Mr. Tellis, the officers that detained Mr. Tellis, didn't have the body cam on, and that was requested multiple times. Ultimately, there was an order from Her Honor on July 18th of 2023, and after that order. And you recall going through the CAM, the reports, the CAD reports, there was intervention, but again, that key piece of evidence was overridden, it was destroyed. Again, is that indication of some wide-ranging conspiracy? And I'm not going to stand before you today and necessarily argue that there was. But what that shows is that Metro makes mistakes. Metro officers, Metro detectives are human. I mean, you think of the old proverbial idea of police officers, they're brass buttons, blue uniforms. They're human beings underneath their titles, underneath their uniforms, and they're just like all of us. They make mistakes. That shows you that mistakes are made on behalf of Metro. And the Las Vegas Metropolitan Police Department is not infallible. Let's talk about Robert Tellis's blood, or the lack thereof, at the scene of the murder. You had seen some pretty good videos capturing that person leaving Jeff Gehrman's house after the stabbing. I would submit to you that it's the state's argument that Mr. Tellis cut himself through that incident. You heard his testimony. You are the sole judges of the facts concerning that. What we do have, in addition to the state's video, is we have this assailant walking away from the 7217 Broad Circle address. That finger was cut. That finger had been damaged by a knife or otherwise severely injured. Wouldn't there be blood? Wouldn't common sense dictate that there'd be blood in the bushes surrounding Jeff Gehrman's body, in the rocks which were recovered, in the sidewalk outside the house? Nothing. And again, it's the state's burden to present you every bit of evidence in their prosecution, and you should take into consideration the evidence that they've presented to you. But by the same token, you should take into consideration determining whether or not they have proved their case beyond a reasonable doubt and they have the sole burden for the production of evidence. Ask yourselves what evidence is missing. Let's talk about Robert Tellis's body in relation to a struggle that the state would have you believe occurred between these two gentlemen. Recall the evidence that we had brought in during their presentation of evidence, and I believe a number of these pictures came through Detective Gaddis. And there's a lot. It's defense exhibits B through V. This is just kind of a capture of these photos, and there's a lot of them to evidence that there were no injuries to his body. Neck, front, and there's more, and we could stand here and click through each and every one, but we're not going to. You can look at them. You can ask yourselves, well, if there was this struggle, where are the markings? Where's the bruising? Where are the scratches? Defense exhibits B through V will demonstrate that there were no such injuries. Let's talk about the cell phone usage on 9/2/2022. You know, the state would have you believe that Mr. Tellis's lack of responses to junk messages mean that he was occupied with murder. And through analyst Aguero, you heard, and you had the opportunity to see through the course of this gentleman's testimony, it was uncontroverted. We went through the messages during the key hours, the key times of September 2nd. The vast majority of those messages were automated. They were spam. How many of us respond to spam? It wasn't like he had every person reaching out to him, family, friends, repeatedly. Where are you? What are you doing? It's not. The vast majority of those messages were of no significance. They were junk. Additionally, the state did not establish a pattern of phone use behavior which would indicate that Mr. Tellis's communication activity on that day was anything different than his normal behavior. They had the devices, they had the access. You heard no testimony that his accessing his phone, his using his phone on September 2nd was anything different than the day before, the day following, the weeks before, or the weeks following Mr. Gehrman's murder. And let's talk about the deleted messages. You recall that was quite a big point that was underscored and argued through the course of testimony, and it was actually through Mr. Aguero, our expert, the issue concerning this deleted message. And you recall then we had the subsequent witnesses in the state's rebuttal that came forward with and it was through Mr. Tellis's testimony. Do you remember the watch, the Apple Watch? Then there was questions asked, what about the other device that presumably these messages were being received on? We didn't get the benefit, and again, it's their burden to compare the Apple Watch with the Pixel phone. We didn't have that. But what we did hear from that detective is that he couldn't say one way or the other. Do you remember that question, where are you? Obviously, if someone's home, they can speak with one another. But we didn't hear and we couldn't hear any evidence. And for you to just make a judgment based upon their own expert, their own witness who has special training and knowledge, say, I couldn't say one way or the other whether that message was deleted on the Pixel device, the device that they have alleged was Mr. Tellis's phone, that's significant. Let's talk about what the state does have. They've got a cut-up straw hat and shoes. There's really no reasonable explanation, rational explanation one way or the other. Obviously, if this person's the murderer, why not get rid of the shoes? You'd have to presume that he had knowledge of the shoes and their whereabouts. Let's talk about that hat. Why wasn't that hat discarded? Again, we'd have to presume knowledge on the part of Mr. Tellis where that hat was. And again, neither the shoes nor the hat tied him to Jeff Gehrman's residence. We had a shoulder bag with balls in it. Do you recall that exhibit? We had a basketball and a football that looked like some sawdust, and you'll have all of these exhibits. What's going on with that? I guess you're to use your common sense, which is one of the latter instructions, and assume that this bag is somehow implicated in the murder of Jeff Gehrman. And then it winds up in a storage area in the family home with a basketball and a football and what I would submit to you looks like sawdust in the middle of it. The image artifacts from the cache of Robert Tellis's phone, as well as the vehicle and the address inquiries on Mr. Tellis's work computer, it was fairly clear through the course of the testimony that that work computer had access to the Google account that would presumably be accessed by his Pixel phone. If one has password to that, one can have access to the devices. Matt Havaness said that he could not say the date of the cached images on the files of Mr. Tellis's Google Pixel phone. We were shown a calendar. We were to draw inferences. We don't know specifically who accessed, who searched for those images, and we don't know when they were created. And I would submit to you that that's significant, and the state should explain that to you. On Defense Exhibit 03, Robert Tellis's user accounts on his Dell Omnipex located the Public Administrator's Office. Again, this is the report. You have it. This is Mr. Aguero's summation of his analysis. Again, it shows that this Google account, where these damaging photos and images are shown, it's the same. It's the same account. It can be uploaded, accessed by both the cell phone and the work computer. Obviously, we know what was going on from the testimony of multiple witnesses, what was going on at the Public Administrator's Office and the turmoil. I would submit that's something that you should consider and determine what the facts are and what the state has proven beyond a reasonable doubt. There is a positive DNA hit for Mr. Tellis related to Jeff Gehrman's fingernails. And you recall at the beginning of the state's presentation last week, you heard from the crime scene analysts, and I would submit to you that it was fairly clear that there was a little less than an airtight investigation because, after all, police officers, detectives, crime scene analysts make mistakes. Reference to the lab techs, Ms. Brown and Ms. Koljenovich, they were trainees at the time that they did this DNA collection and the processing for presumptive negative or presumptive positive blood evidence. This is significant. It was Claire Manning. She had testified, she was young, blonde. She had testified that she couldn't recall who bagged the hands. That was at the scene of the murder. You never heard testimony as to who initially bagged the hands of Jeff Gehrman's body. One would think, and common sense would dictate, that they'd be able to tell you that. They couldn't, not from a single witness. She testified that she took custody both of the fingernails and the evidence concerning Mr. Tellis, but again, she couldn't tell you who bagged the hands. Again, this Google search on the recipe, you heard that the last day of trial, like that was somehow significant. Do you recall in the recross of the detective, there was at least 2 computers at the Tellis home that were not reviewed. They weren't checked for those recipes. So again, I'd submit to you, we have a wash. Detective Mogg, Christopher Mogg, he's now retired. He's an analyst, he lives in Texas. You recall at the beginning of this trial, he gave what appeared to be fairly detailed testimony concerning the whereabouts of the subject Denali. Do you recall on cross, it was addressed that at 9:10, that vehicle was entering in from the Piggott Elementary. And again, you saw the map. It's in evidence. You can see that this right here is not the entrance to Mr. Tellis's neighborhood. It's streets away. It's not close. He gave you testimony that apparently he drove through the neighborhood where Mr. Tellis lived, off the Spanish Steps address. He said to look for things of evidentiary value. We heard nothing. We heard nothing concerning other vehicles in the neighborhood. Do you recall the testimony that there was at least 67 red Denalis? We heard testimony that that number at one point perhaps was greater. Perhaps it was at 67, which nobody contradicted, but we never heard what it was ultimately narrowed down to. We had Detective Mogg, and I'll refer to him as detective because in essence he still is. He testified and just said he was sure that it was that man's Denali, period. Do you recall the testimony that was shown concerning, and I would submit to you because you are the sole judges of the facts, that there was something peculiar about this Denali, something in the right-hand window area, that plastic stripping? You have the photos. Please look at them. We are given testimony based upon his analysis. We have at the same part near Piggott Elementary, we have this vehicle leaving at 9:12:32. But what's significant about the 9:10 where we see it entering the neighborhood or the area, again, it's not Mr. Tellis' specific neighborhood, we're not told where it was before that, who was driving it. What's important, and I want to back up, is at 9:10, we have this vehicle entering the area. And you have to ask yourself, what's occurring between 9:10 and 9:12? If we're to take the state, based upon the evidence that they have presented, what went on during that 2 minutes and a few seconds? We don't know. Did it even make it to the Tellis' house or some other neighbor, other house in the area? But as to the 9:10, it's important because it's the state's theory, and we heard it argued that Mr. Tellis left his phone. Well, we have, and this is Defense Exhibit A3, we have that phone receiving messages. Look at the times, all throughout the morning. We have that phone receiving messages 7:44, 7:45, 8:47. You can see, and this will be given to you. It's close to the cell tower next to Mr. Tellis' home. So then you have to ask, well, where was this vehicle? And I'd ask him specifically, did you follow this vehicle? Did you see this vehicle prior to the 9:10 time taken from Piggott? He didn't. But we can see, based upon the evidence that was provided to you by the defense expert, that phone is in the area all that time. It's in the Spanish Steps area. So obviously the argument, and I would submit to you, common sense would dictate, well, if that is going to Mr. Tellis' home and it's not arriving in that area until 9:10, why do we have all of these other pings at all of these other times close to the home, if not at the home? He laid out very specific detail, and he had talked about this approximately 5.3 mile trek that he wants you to believe was Mr. Tellis' vehicle, and that vehicle was occupied by Mr. Tellis. His video analysis takes 2 hours, it covers 2 hours and 39 minutes. State couldn't show you what happened during that 2 hour and 39 minute period. 5.3 mile trip to and from. They basically show you closed circuit TV coverage, which it wasn't. There was a lot of dark spots of the vehicle driving there. But then the vehicle driving back, and I won't say it was driving to and from Tellis' home because we have no evidence of that. We're to believe the state that there's no ring cameras in a fairly affluent neighborhood. I'd submit to you, does that make any sense? What we're going to ask you to look at, and please do, you know, you've done a lot through the course of this trial. It's your duty to be here, and you have fulfilled that duty. You've taken notes. Through the very last witness, it's been apparent that you've been paying attention, that you've maintained an open mind. You know, oftentimes we suffer, especially law enforcement, from what's called confirmation bias. You reach a judgment, sometimes early on in the case, and you work backwards to confirm what the judgment that you've arrived at the beginning should be at the end. And I would submit to you that that's what happened. This was the 1405 wintergreen. As you recall, there was an issue concerning the timing. This was channel 3, all right? This is State's Exhibit 372. You have that. You'll be given a laptop. Look at this. This was an image that was not part of his presentation to you at his testimony and during his testimony. This laptop has the ability to pause. It has the ability to zoom. Watch this. We're going to slow this down now. You have this evidence. It wasn't part of his presentation, but it's been provided to you. Look at the profile. What's that look like on the top of the head? I'd submit to you that looks like hair. We've seen Mr. Tellis. He gave testimony from the witness stand. Does that profile match the profile in that vehicle? I mean, it's no secret. The man's bald. Look at the face. Look at the eyes. I'd submit to you that those look like glasses. And again, this is part of the evidence collected by the state. It's been presented to you. It wasn't addressed during their case in chief, and it wasn't explained by Detective Cliff Mogg. I'd submit to you, look at that image. There's hair. There's glasses. Now, the state in rebuttal, and we'll address the significance of that, they have the opportunity to come and address what I've presented to you, but that's undeniable. What I'm going to show you next is the image on channel 2. That's the same video coverage, but now it has the vehicle coming from a different direction. It's parked. Do you remember the testimony from Mr. Martinez? I think it was John Martinez, of no significance. It was fairly unmemorable on that date. He said he saw the person. Nothing caught his attention because nothing was memorable. There's no talk of a disguise. Glasses, nothing. It's bland. Nothing was memorable. Take a look. Oh, hang on. That's Mr. Martinez that I had discussed. Look at this image. Look at the profile. It's hair. We have two captures from two different angles. The profile does not match the profile Mr. Tellis. And they're consistent. It's not open to dispute. You know, you've heard testimony, and you heard it primarily through Mr. Tellis. You heard it from Nicole Lofton. Mr. Tellis was fairly concerned about the goings-on with Compass Realty in relation to heirs, in relation to the trampling upon the legacy of heirs by the mismanagement of the properties that were left through intestacy. I would submit to you that Detective Jappy inserted himself into the murder investigation. And again, I want to draw, a couple of arguments from this Compass Realty testimony. I mean, we know that Mr. Tellis was very concerned about Compass Realty. He was the whistleblower. He was concerned about the actions of Compass Realty. You know, during the 2 years that he's in custody, I mean, what would a man do? He's fixated on that. He's ruminating on that. I would submit to you that common sense would dictate, and your experience would dictate, well, he's going to focus on the involvement of individuals who he was focused on prior to his being arrested. I mean, really, what are his alternatives? And again, this goes back to the burden on the state and not the defense. What can he really do when he's locked up? He's going to focus on Compass Realty. It's easy to dismiss him as being crazy. Oh, that's Looney Tunes. But hey, he's been in custody for 2 years. He was worried about Compass Realty prior to being incarcerated. He was worried about the goings-on with the old guard, about his work at the public administrator's office for financial reasons he testified concerning, and you've heard testimony supporting that. Why wouldn't he continue worrying about that? Why wouldn't he keep thinking, well, I'm being framed, I'm being charged with a murder that I don't think I committed, I didn't commit. He's going to focus on what he was focusing on before he was arrested. You know, we heard testimony from Detective Gaddis. Do you recall the exhibits, the information that was presented about the release on September 5th? The video release of that individual walking. They started getting tips. Do you recall the email that was in her 70-page officer's report where she had communicated with Detective Jappy predating that? The first communication that we have on record and that's referenced is September 4th. Detective Jappy, when asked, did you incriminate him? Did you give him, did you give her evidence implicating him in this crime? And he said, I gave her information. But then we heard from Detective Gaddis that she had a communication with him again on September 5th. And again, she was given motive. In Detective Jappy's mind, she was given motive to focus on that man and his alleged motive to kill Mr. Gehrman. So he wouldn't agree from the stand that he implicated Mr. Tellis, but to call a detective or to email a detective on September 4th, and then again on September 5th and say, look at this guy, he's got a motive to kill. How could it be anything but an implication? You heard crime scene investigator Baxter. Her testimony concerned the goings-on at the public administrator's office during the execution of a warrant on September 8th of 2022. Her testimony, and it was adopted by Detective Gaddis, she stated Mr. Jappy, she said Detective Jappy, was taking his own photos and collecting his own evidence during the search warrant at the public administrator's office on September 8th. And it wasn't a mistake, because it was asked of her on cross, and it was confirmed what she had said before you, the sole judge of the fact, by Detective Gaddis, the primary detective concerning this homicide investigation. We had heard testimony that Mr. Tellis, as a result of the warrant obtained by Detective Jaffe on August 17th, 2022, that man was under surveillance. It appears until Detective Jaffe inserted himself into this investigation, we had dual investigations, a short one and a much longer one concerning Robert Tellis. We know from Detective Jaffe's testimony that he was exonerated. There wasn't this kickback scheme. He had been implicated by an agent who was a real estate agent who was a detective at the time. That provided to Detective Jaffe in part the probable cause to get that warrant. So we have a member of Metro giving another member of Metro evidence, testimony, opinions about a kickback scheme implicating Robert Tellis. We also had heard through testimony that Compass had a direct line into the Public Administration Office. And again, I discussed Mr. Tellis as being incarcerated because I would submit to you it's understandable why he believes there's this wide-reaching conspiracy. What other options does he have in his circumstances, under these circumstances? We do know that the District Attorney's Office refused to pursue action against Compass Realty, and again, I'd submit to you that that's significant. You know, the purpose of closing argument is for counsel to stand before you and highlight the evidence that's been presented to you. I'm not going to stand here and go through every witness, discuss every piece of evidence and all the testimony because you have been here. You have been attentive and you are fulfilling your duties. You're being good jurors. But again, my job is to argue the law and, in essence, the facts to you and what we feel is significant. As I said at the beginning of my remarks, it's the state's burden, and the state's burden alone, to prove this case beyond a reasonable doubt. This is our last opportunity to discuss matters and discuss the evidence and the inferences to be drawn from the evidence. Mr. Hamner now is going to take the floor and he's going to argue concerning matters that I perhaps didn't bring up. Address those on your own. Look at the evidence. You've got over 36 exhibits that were marked and admitted through the defense in this case. Watch the videos. Look at the drive concerning those images of that gentleman with hair, which Mr. Tellis does not have. But since the state carries the burden and the state alone, they get the opportunity to get 2 bites of the proverbial apple. Mr. Hamner now can stand and argue why you should convict Mr. Tellis. And I'm going to ask you with your open minds and your attentiveness to address those concerns. And at the close of this process, you find Mr. Tellis not guilty.
Thank you very much. Mr. Hamner, you may begin your rebuttal.
Yeah, if I can just get a minute just to set up.
Sure.
Okay, thanks so much.
So what do you all think of that that response by the defense? He said, look at this image. This guy has hair. My client doesn't have any hair. They're saying this guy driving this car is the assailant. Well, if that's the assailant, it must not be my guy. Because my guy's got no hair. What do y'all think about that? It sounds to me like he was saying, look, yeah, you might think my client's nutsy cuckoo for believing this Compass Realty conspiracy theory, but it makes sense for him to believe it. I'm not saying I believe it. I'm not saying you should believe it, but it makes sense for him to believe it because he's been in jail for 2 years and that's all he's had to think about. He hasn't had access to any much new information because he's been in jail. So he's just been thinking about this Compass Realty connection all this time. All right, we're about to hear from DA Hamner. That's who everybody wants to hear from. Looks like they're about to give it to us. How's he going to wrap all this up? How's he going to respond to what Draskovich just told us? So now there's more costumes, Natalie. So he got rid of the orange shirt. He got rid of the pants. He got rid of the gloves, and now he got rid of a wig too, and a beanie, and sunglasses.
Everybody hear me okay? All right. This is quite the setup. Okay. May I proceed? All right. Well, it's been 2 weeks. You guys have heard a lot of evidence. We thank you for your patience, and I will try to be as brief as I can. But as you've seen, with witness after witness after witness, the evidence is absolutely clear. The defendant murdered Jeff Gehrman. He murdered him because Jeff's writing destroyed his career. It destroyed his reputation. It threatened probably his marriage, exposed things that even he admitted he did not want the public to know. And he did it because Jeff wasn't done writing. He was informed on August 8th that a records request was being made by Mr. Gehrman long after he had lost the race, well into his lame duck remaining administration as a PA. And he learns that Jeff wants to write more. And when he learns about the subject of it, it's not about him and Alicia. It's not about him and Rita. It's not about anybody except him and Roberta. And what you see unfolds over the course of a month. We learn from his phone expert that he shut off all location data, even though that phone, as we learn from his expert, 13 years of location data magically disappears for the month of August. Why? Because of the August 8th email. He's over it. He's building a reconnaissance case. He starts to go on to Google Maps. He starts doing surveillance at Popeyes. He's using the power of his office and their computer software to find private details about Jeff, so it can culminate in murdering him. And that's what he does. But as I've told many, many juries, especially in the last few years, it is really, really hard to plan the perfect murder in the digital age because you leave too many breadcrumbs behind. And he's no dummy. He's actually quite smart. He is thoughtful. But you will see during this rebuttal, there are mistakes that he makes. And there are things that he simply cannot account for that when a police starts to look into an investigation and deploys the tools that the police have at their disposal, it uncovers the inconsistencies. It uncovers his mistakes. But I gotta start with what he got up and told us about, the alleged conspiracy. When Mr. Tellis got up here over the course of, I think it was 3 days and testified, it was remarkable what he had to say, and not in a good way. His testimony was incredible, and not in a good way. He explained, or at least attempted to, explain this conspiracy. What we learned over the course of the 3 days, and actually the course of this trial over 3 weeks, is the conspiracy grew, and it grew, and it grew. Who's exactly in it? It starts with Compass, nebulously Compass Realty. We learned that Adam Fenn can't be ruled out, right? Because he makes donations to Rita Reed. Cindy Sauerland gets mentioned at one point. In some of those briefings, you'll see her name is mentioned. She's a source of consternation for the defendant. It expands to the old guard, as they coined that phrase. Rita Reed, Alicia Goodwin are all part of this, right? The conspiracy, and let's remember, it's a conspiracy to murder Jeff Gehrman. We then learn it expands to Derek Jappy. He's in on it as well. When he testified, he's not really able to link up why Derek Jappy would want to help Rita Reed or Alicia Goodwin or Compass Realty or Adam Fenn or Cindy Sauerland. That testimony is lacking. A lot of times when I pressed him, and I pressed him, and I'm going to explain to you one of the reasons why I cross-examined him so hard. When you stand on the stand under oath and you make allegations about businesses in our community, government service workers, and the police department, we deserve answers. I genuinely wanted to know, how is all this connecting? Explain it to me. And respectfully, Mr. Tellis absolutely failed in doing so. It didn't make sense. And that is one of your instructions, which is to use your common sense. It's got to make sense, and it actually has to link up with evidence. But a lot of times, the most common answer I would get back from Mr. Tellis was simply, well, no, I never saw Jappy take a bribe, but I think that. It was a lot of times it's like, that's just my gut feeling. That's my opinion. That's not evidence. That is not evidence. But yet, it was Mr. Tellis's answer for almost everything when it came to this conspiracy. But let's continue. It stretches out to include Cliff Mogg, Justine Gaddis, the entire DNA lab. He said there were also patrol officers in it. I asked him which patrol. I don't know which ones. And then it literally culminates with Steve Wolfson, like the DA. It culminated with him. He can't quite link it up, but he threw that name out there. And here's the thing that struck me when I took over this case. I would submit to most people, probably before ever hearing about this case, had no idea what a public administrator was. He is not a U.S. senator. He is not a governor. He is not a congressperson. He is a duly elected official who manages an office of approximately 8 people. And their job is to assist people who pass away, who don't leave a will and leave property behind. The public administrator's office is not at the forefront of everyone's mind in this community. No one learns about this until who brings the office to light? Jeff Gehrman. And what's amazing is if you believe that story about this conspiracy, all of these people and all of these entities were willing to sacrifice their reputation, their business, their police department, even the public administrator's office. They're all willing to put it on the line to kill a reporter, to get that guy, even though he's leaving in 3 months? Does that make a shred of sense? Absolutely not. But what it does give you a window into is what's in his mind. That is how important Mr. Tellis views himself. That every single one of these people, every single one of these entities were literally willing to kill another human being who is not him just to frame him. Does that make sense? And more importantly, where is the evidence to support that? Where is the evidence that you received in this trial that supports that? And the answer is you didn't. There isn't any evidence of that. Why would Compass conspire to frame him? Why? I asked him. I wanted to know. He couldn't give a good answer. His best answer was, well, I was going to do a lot of work in the next 3 weeks, or next 3 months. Has anyone ever heard of any sort of legal filings, lawsuits getting settled up in a brief, tidy 3 months? That's not a thing. That didn't happen. That doesn't happen. There was no need to frame him because they already succeeded getting him voted out of office. And all they had to do was donate a whopping, I guess, 15 grand at best to get him out of office. They didn't need to kill him. He was on his way out the door. He is a lame duck. And lame ducks don't matter. What incentive does Metro have in this conspiracy with a real estate company to frame a lame duck? That's an even bigger one. Why would they do that? What did we hear that would show us that Compass is like, hey, guess what? Hey, Metro Homicide, we need you to join us to go frame this outgoing politician. I mean, we killed the reporter. That's not important. But I want you to join us in this, and let's go frame this guy. And all of Metro's like, sign me up. Sounds great. Does that make any sense? Absolutely not. It makes no sense. And it's not supported by the evidence. And again, if Compass is literally willing to kill, why not just kill him? Just kill him. Why does Jeff have to suffer? It makes no sense. And it gets even worse. Well, before we get to that, here's the thing. When we go back, when you think about the Compass question, right? Isn't Compass in cahoots with Rita Reid and Alicia Goodwin, right? They're funding Alicia Goodwin, right? Or no, Rita Reid. They're funding her campaign against him. And who do they get to help write the story? Jeff Gehrman. Like, why would they kill the guy who wrote the stories that got this guy out of office? Why would Compass do that? That doesn't make sense. And then, yeah, if it's really a frame job, the murder weapon should have been in the house. The orange shirt should have been in the house. The DNA should have been all over the place. Like, they're claiming, well, why weren't these things located? The state would submit to you, he got rid of them. He got rid of the murder weapon and the orange shirt. He cleaned the outside of his Yukon. He even admitted it. And here's the thing. We only know that he wiped down his Yukon because on that one particular day, he was being watched. He wasn't watched every single day after the murder by Metro. Did you hear that testimony? There were other days he could have wiped the interior of his car if he wished. And I've always thought about the shoes. Like, the shoes to me was kind of an interesting one. My co-counsel's right. Like, the only one who benefits of like chopping up the shoes is Mr. Tellis. It's this awkward, amateurish way of getting kind of rid of the evidence. But I thought to myself, maybe Mr. Tellis didn't even think to like bring an extra pair of shoes. Because like, what happens if he walks in and he's totally barefoot? His wife would be like, why do you have no shoes on? He probably had to bring his shoes back in. He doesn't need the orange shirt. He doesn't need the murder weapon. It is his kid's bag, right? I mean, he said that's my kid's sports bag. So like, he probably needed to bring that back. I'm not sure what he was doing with the hat, I'll admit. But clearly he's chopping it up to try to get rid of it, just like his shoes. And why kill Jeff? Like, this is the question that is so destructive to this defense. It's his writing that shines a light on his behavior. He is sought out by the co-conspirators to do this. And he admits, And he admitted on the stand, one of the rare times he admits it, he admitted, yeah, his writing was the difference in the election. That's why I lost. I got that out of him. He was at least willing to concede that. But for Jeff Gehrman, he's still a public administrator. His writing is why the defendant is out of the job. And therefore, under this theory, he's got to be the one who's killed. That's his reward. He's collateral damage. Like, really? Rita and Alicia are like, sorry, Jeff, you got to go. It's been really nice. Thanks for the help, but you're out now. We got to clean up loose. I mean, is that really what's being suggested here? And the answer is that is what he's suggesting. But it defies common sense, and it's not supported by the evidence. And here's the other thing. Jeff's putting together a fifth article. And now, what we can tell from the records, it's just about Roberta and him. It's the salacious stuff. So who in this realm, if you think about everyone in the conspiracy, and you think about Mr. Tellis, who is the one that wouldn't want another article written about him engaging in an affair? You think Derek Jappy cares? Cliff Mogg? Adam Fenn? No. It's him. He's the only one that would have a stake in making sure that article never got written. No one in the conspiracy would want to prevent that coming out. Especially not the Rita Reeds and the Alicia Goodwins. If they want that exposed, I mean, they went to have that exposed. They wouldn't want that being not put out. And I'm sure Compass Realty wouldn't either. I'm sure they would wanted him discredited. Like another article would in theory be great. They wouldn't have killed him. And then we have his walk. Like, he's got a little hitch in his getup where he kind of leans to this one side. You can kind of see it. There's something that is about his little walk. And look, you don't have to take my word for it. You can evaluate whether you think what Zach and Christy had to say about it. They've hung out with him. They've walked with him. They thought, and think about how they saw it. They were like, man, they kind of knew the background between Gehrman and Tellis, and they were like, wouldn't that be funny if that was him? He's got those same goofy gray shoes. Like, that was the thing. Like, they noticed the shoes, which I think is really interesting, you know? But they don't act on it at first. But it's only when they see the Yukon that they kind of flip out and they're like, well, we probably should call on this. The only other person who came and said that wasn't him is Nicole. And listen, you'll have all of Nicole's texts. The state would submit to you that, look, there is no doubt she has a kinship to Mr. Tellis. You can see it in the text messages. You can see it. You can go read through them. The state would submit she has a bias. And, like, she cares about him. And I think he was probably good to her in the office, which is understandable. But, look, you can judge it on your own. You can judge the testimony of those other people. You can make that call for yourself. But I would submit to you, when you look at this, think about all the other evidence in the case. Think about all the other evidence, the motive, the physical things found in his house, his DNA underneath the nails. When looking at this and being like, is that him? And the state would submit to you, when you put all that together and you watch this video, absolutely, it's him. Professional killer versus amateur killer. Mr. Tellis would like you to believe that this was an assassin with combat training. The state would submit to you, you don't need combat training to stab people. You don't have to go to knife school. You don't have to do that. If you're angry enough, you can stab people pretty good. If you got enough hate in your heart, you can really go at people. And I would submit to you, the state would submit to you, that Mr. Tellis had had enough of being exposed, written about, publicized, embarrassed, and he wasn't going to have it done again. Because at this point, the state would submit, Gehrman had taken everything from him. Everything. Everything that he worked for. He worked his way up through law school. He got himself elected, and this guy took it all from him. And so he wanted to take something from Jeff, and that was his life. Professional assassins don't use their personal vehicles. They don't use their personal phones or work computers to conduct reconnaissance. They don't wear attention-grabbing outfits. They don't flee the scene and then double back to pull right up to a murder scene to look for possibly dropped evidence. And they don't leave items of clothing or apparel they use in the murder inside their own house. Professionals don't do that. The state would submit to you that what this was an amateur attempt by Mr. Tellis to pull off this killing. But here's the thing. It is thoughtful. It is deliberate. He really did a thoughtful job about it. I give him credit. I give him credit. But in the world of the digital age, we leave behind too many breadcrumbs. And when you're not a professional and you are an amateur, you tend to make mistakes. And that's what he did. For example, really smart idea. He knew about IDI Core. Hey, I've got a really easy way to look up personal identifying information on people. I'll use my work computer. But what does he not realize? That we can, as the police, download the computer and literally see your keystrokes. How could he have known that? He wouldn't. It's an oversight. It's a mistake. It's a slip. And it's evidence that we collect against him. What else? He does the Google Maps surveillance. Really clever. What an easy way. You don't even have to go to the neighborhood. Just pull it up on your Google Maps. He does the Popeye surveillance. He takes the photos off of his work computer, right? But he forgets to delete his cache files. And let's just make this clear once and for all. Matt Hovanetz told us what? He said that these are not created photos. They would say created in a date and a time and you'd have it. Those don't exist on the phone. I wonder why that is. Why do you think there aren't all those images? Forget the Google Maps surveillance, right? That's just, those are probably images that the program pulls up. Sometimes it's referred to as tiling. But like the Popeyes photos, which are coming from the phone, and the one from the work computer, why don't we have any created photos? The state would submit to you that Mr. Tellis, being the smart guy that he is, the techie, as he describes himself, deleted them out of his photo album. But the problem is, he didn't delete his cache. And we learned from Matt Hovanetz that the caching of photos is what happens. The example that we heard was, say you want to send an email, and the computer will shrink down the actual image to get down data size lower so it can go out. He didn't delete the cache. He deleted the actual photo, but not the cache. And so those dates tell us that essentially in the month of October, he is doing all of these things. He tried to get rid of it. He couldn't get rid of all of it because he's an amateur. He conducts reconnaissance in August, but doesn't realize that the police are going to acquire the 8.8 email about the public records request, right? Like, did he really? Maybe he probably didn't realize that we would go to the PA's office and say, hey, we want what communications are out there, and we get the email. Now we understand the significance of why these things are all happening in August, because we get the email. He didn't account for that. Here's another thing. He shut off all his location services in August, but doesn't realize it's going to stick out like a sore thumb during a location services analysis. And here's the crazy part. His expert gave it to us. His expert said, I have 13 years of location data on this phone, but for the month of August, it's a 0. It's a bagel. Why? Why that month? Because it's when he's planning the killing. He knows he's going to those spots. He doesn't want to be tracked. He's no dummy. He's smart. But the problem is, that is an electronic breadcrumb. An entire month, no location data at all for anywhere that he traveled? That was the testimony of his witness. And he didn't claim that that information was hacked or compromised. What else? He decides to wear gray Nikes, but forgets to delete the shoes off his phone. And then he fails to get rid of the shoes in time by the time the cops do the search at his house. Maybe life just kind of gets in the way, right? He's maybe doing it late at night when the kids are asleep and his wife's, doing a little, I don't know where he's planning on sprinkling the bits of the shoe, but like clearly he wants to do that to shrink it and maybe it's harder to find. Like he's putting it in a place that only he would find it, like underneath the recliner. And like, he can't account for like the one random photo where like his murdering shoes are right there when he's out rock climbing. Like, he can't plan for that. And all the hundreds or thousands of images are there, he can't plan for that. creates the disguise of the construction worker, but it doesn't account potentially for an interaction. And then again, he leaves his phone at home, which is smart, right? So we don't see the movement of the phone kind of going with the Yukon, right? But the problem is that when you go radio silence for like 5 hours and you start ignoring your wife's calls and texts, that's a problem. And then, great example. He gets up here and he tells us the whole story about the chicken fried rice. He was so happy to share that story. I was making my daughter lunch because she doesn't eat the school lunches, and I cut the tip off and I started bleeding, so I went and got the super glue and I cut it and it got blood. And so that's why the DNA, that's the one time he was fine with DNA. But like, he doesn't realize that all we have to do is start checking it. Is there a Google recipe for chicken fried rice on your phone? And there wasn't. Because that's what he said he was doing. He didn't just say I was making a meal, he specified how he was doing it. He was like using a recipe, and that's the most logical place you would do it. People are not bringing their desktop computers and putting it in their kitchen when they're cooking fried rice. Like, that's not how that's going down. Like, if that their story was true, and we would submit it as not, because it's not there in the phone, he probably would have sat there with his phone on the counter, hit the YouTube or the Google recipe, and then he's working. So it should be there. But it's not. Because that was something used to explain why in the world would my DNA be on the scissors. Again, another example. He goes to great lengths to park down the street. And then it all goes down the drain when he leaves because he realizes, oh, I probably forgot something. So he wheels back and parks right in front of the house. That's a huge mistake. It's an amateur mistake. Here's another one, and I just noticed it while watching it. He left the garage door open. If you watch the video, after he does the killing, he walks away, the garage door is totally open. And then when he drives back and he gets out, he has 2 opportunities to close the door. What did we learn about what prompts the neighbors to worry about Jeff? It's the garage door. The hitman, the assassin shuts that garage door. But not an amateur, like Mr. Tellis, because in the panic of the moment, he's just like, I gotta get out of here as quickly as possible. It's a slip. It's a small slip, but it's reflective of who we're dealing with. And then he forgets to get rid of the hat. He forgets to get rid of the bag. He forgets to wipe his phone entirely. Next time, factory reset. Full factory reset. Hopefully that'll clear it all. Probably be up in the cloud. But the point is, he doesn't do the things he needs to do. They're amateur mistakes. It happens. But that's why it's hard to pull off the perfect murder in the digital age. And about that gray bag, the defendant told us on the stand he'd like to think he wouldn't have removed his children's basketball and football to use it in a murder. Remember that? And there's the bag. And there's the bag. And there it is. And the defense in his closing arguments said, we submit that there's sawdust inside the bag. Well, let's take a closer look at the sawdust. See that bag? Let's take a closer look. Remember the big sun hat? Is that sawdust? Doesn't look like little chopped up little bits. Looks more longer and rectangular and flat. Here's the hat. Here are those bits, long and rectangular. The state would submit to you, he put his chopped up hat in that bag and then transferred the bag into the Sprouts bag, put the basketball and the football back inside. That is not sawdust. I want to touch on some things that were brought up in closing argument. That Guerin's DNA is the only one at the scene. Well, our response is, well, his DNA is underneath Guerin's nails. So that's a huge problem. Not in his vehicle or in his clothing. He got rid of his clothing. We'd submit he cleaned his car. He also wasn't surveilled 24 hours a day. There was no positive ID from him at the scene. And that is correct. And listen, that's why we have this instruction about direct and circumstantial evidence. Because in Nevada, the law doesn't make a difference between the two. You can weigh it as you wish. Some cases have incredibly powerful examples of circumstantial evidence. Sometimes you've got a combination of both. Sometimes it's all direct. But but there's tons of direct evidence, like him in the Yukon, like that's to be tracked from literally Silk Tassel all the way to his house and then all the way back is incredible. You heard about how many officers it took to track and go business to business to business to business. That's direct evidence. You've got the circumstantial evidence of his DNA. You've got the shoes with his DNA in it that's chopped up. You've got the hat. You have the surveillance in the phone. You have the whole motive laid out from the articles. I mean, okay, you're right. We didn't have one person standing out going, I watched Mr. Tellis stab Mr. Gehrman. You're right. But we got a whole lot of other evidence. There's no surveillance of Tellis exiting his home. You've heard testimony about it repeatedly. There wasn't cameras in the area. We just have surveillance of the street that's perpendicular to his driveway. And I thought I had pulled up, maybe I didn't, I apologize. I tried to put the image of that, but I want to address that. It might be still in here. Go back and check the map, because the way it actually works is Piggott Elementary, when he's coming in and out in his red Yukon and going to the gym in his BMW at the end, the street that comes down perpendicularly to turn out along the Piggott Elementary, that street is Silk Tassel. And when you look at a map, if you follow Silk Tassel, it perpendicularly, it runs into his driveway. Like all he has to do is like drive out of his driveway and he's already on Silk Tassel. So you're right, like we don't have him getting out of his car from his driveway, but we literally have the only street he needs to take to get to Piggott Elementary. It is not streets and streets and streets. It's the street before his driveway. There's the argument, well, Metro makes mistakes. There's that deletion of a traffic cone. Well, as I've just pointed out, Tellis made a ton of mistakes himself. So we will own that, you know, on one traffic stop, we didn't mark a proper event number. And you can give it whatever weight you want. Tellis cutting himself while cooking. You know, again, we've talked about the chicken fried rice thing. That's not backed up. Wouldn't there be blood from the cut? Not necessarily. What if he had gloves on? And he's kind of cutting his tip. It may not be pouring everywhere. And again, look at that scene. The majority of the blood of Mr. Gehrman is actually just kind of pooling from where he's resting. It's not splattered all over the house walls. It's not that type of scene. I mean, Gehrman's shoes are such a good example of that. Like, he's the guy who gets killed. He's the one stabbed 11 times, and his shoes are relatively clean. And he's not doing a lot of walking. A lack of responses to junk messages. That's true, but there are work messages he's not responding to, and his wife is reaching out to him, and he ain't responding for hours. That's a problem. That's a problem for him. Especially, go look at, when you're not in the murder window, go look at the communications. So like when his daughter reaches out to him in the morning, he responds like that. No issue. Like at 3 o'clock or so, or 2:30, when Tonya, his ex-wife, responds with a question about the kids, he responds immediately. And what did he tell us on the stand? What did he tell us on the stand about being at Summerlin Area Command? What was his big worry? My family doesn't know where I am. I was so worried about being detained there because I couldn't reach out to my family, because that was the most important thing. And what do we know on the day of the murder in the murder window? His wife wants to know where he is, and he's not telling her. That is significant, because his pattern is, when you look outside the murder window, he promptly responds to family members about family matters. But he goes silent with his wife when he's literally in Mr. Gehrman's neighborhood. And another thing, remember his face when I showed him the Apple photo for the first time? If anybody remembers, store that one away. Because he was very comfortable on direct talking about the timeline. And he had his story all lined up. And when I showed him the photo, the message that wasn't there, that face really changed. And you can weigh that when evaluating his credibility and his responsibility for this. And then there was the argument about DFL analyst Hovannes couldn't say one way or another if it was deleted. Well, you're right. He's like, I can't definitively say it. What he does say is, I can see from the photos the message is there. I can see in the timeline it's not there. Sometimes there are situations where people delete things deliberately and it's marked as deleted, so it'll appear in an extraction report. But sometimes people delete messages and it's not. But he can't definitively say for certain. So I would submit this to you, ladies and gentlemen. Look at all the surrounding evidence in the case. And then you can reach a conclusion about this. Because, ladies and gentlemen, circumstantial evidence is a chain of facts that lead you ultimately to a conclusion. It's like connecting the dots. And so if you're wondering about this, look at the phone evidence. Look at the motive. Look at the physical evidence in his house. Look at the timeline of when he's gone. Look at when the Yukon is where it is in relation to just nothing is going out on this phone. And then you decide, you can make a call about whether, and his manner on the stand, listen to him testify, and then you can decide whether he actually deleted that message. And I'm going to get to the significance of why maybe that message was deleted in a bit. And again, claims Hovannes couldn't tell you the cache date on the phone. The state would submit, and you can check your notes, that's not his testimony. He never said, I can't tell you the cache date. He said, I couldn't tell you the creation date. He said, the cache date is something different. That's what the report is showing me. That's the last time this image interacted with the phone. So that's the time that those smaller images are interacting with those phones, all those dates in August. Not bagging the hands. And that was an argument being made. Like, no one could tell us exactly. So I would say, what means what? Has there been testimony that the DNA evidence was compromised? There was no evidence of that. What is being asked of you? You're being asked to speculate. And you have an instruction on reasonable doubt. And reasonable doubt must be actual, not mere possibility or speculation. Speculation doesn't get you there. It's improper to speculate. Ah, here it is. I knew I didn't forget it. Colin was streets away from his home. That's not correct. That's his house. This is the road. When you're watching that Yukon come in and out, and his BMW coming out, this is what you're seeing. So you're right, we didn't get any homes in this area with camera footage. But we got about 5 miles worth other than that. There was an argument, does it make any sense that there aren't any other cameras in the neighborhood? And my response would be, did you see Mog's presentation? Does this appear it would be a case of Metro's not interested in collecting video? There's like 28 sources. The state would submit to you, if there was a camera that was working, that was closer to his house, they would have gotten it, and we would have wanted it. And then there was the video that they showed of this other car, right, with someone presumably with hair and glasses. The state would encourage you, by all means, go compare it to the rest of the videos. Compare it to the rest of the videos. And compare it with all the other evidence, and then you get to weigh it. Because we did hear from Mr. Martinez. What did he also say was going on in that neighborhood? There was a 7-day-a-week, 24-hour construction project where they're repairing a sewer line. I asked Mr. Martinez, what did you guys wear? We wore orange things, right? And in that video of that car, there's someone in an orange thing. Is it possible that that's one of the workers from the sewage project? He seemed to be coming down the road in that first video. He's coming from the road where Mr. Martinez said he was waving people off, remember? Martinez said, I saw that when we saw the first video, right, of the car approaching and the white truck pulls up, he said he was going out there to tell that person, you can't come down this other way. And the video that the defense shows you shows a car coming from that other way. And if we marry the testimony of Mr. Martinez, the state would submit that's the construction area. In all likelihood, that's just another worker. But you get to weigh it. You get to weigh it with everything else. Then there's this argument about Jappy mysteriously inserting himself in the homicide event. Really? Is that the testimony? Detective Jappy told us that he had to attend the Metro briefing that night. Why? It makes sense. He's literally a detective that's working on an investigation on him. Does it make sense that Metro would want all people maybe involved or some kind of connection? Absolutely. But did you really hear a situation where he was injecting himself into Justine Gaddis's investigation? The answer is no. Detective Gaddis talked about contacting him from time to time, and when contacted, he either met the person or responded, but there really isn't any evidence of him interfering with an investigation. And then here's the other thing. There's testimony from a CSA saying he was taking his own photos and collecting his own evidence. What is the significance of this? We do know from Detective Jappy, he is conducting 2 investigations at that time for Compass and Telus. It goes on until January of 2023. So is it possible he is collecting information tying to one of those? It's possible. But the better question is this. What evidence do we have that Jappy's presence being there compromised any CSA's collection of the information they needed to get? Did you hear a CSA say, like, he didn't let me pick up that computer that I needed to take? He didn't let me take Roberta's computer. Did you hear anything like that? That he was some sort of obstacle from the CSAs doing their work in the PA's office? The answer is no. So what is the point of bringing this up? It is an argument or suggestion asking you to speculate because there isn't any evidence that he interfered with their collecting of evidence at the PA's office. It's not there. And then the DA didn't pursue charges, and I would submit that was significant. That's what he said. Respectfully, the defense doesn't expound upon the significance. He just said it was significant, but doesn't expound why. Why is that significant? He never explains it. It just stops. And the state would submit to you the testimony of Derek Jappy is really significant because Mr. Tellis would have you believe that like he's being framed by Derek Jappy and his complaints about Compass are not being taken seriously, and he got up on the stand and Derek Jappy told you the exact opposite. He exonerated Mr. Tellis from what he was hearing from Reader Reed and people in the PA. He exonerated him. But he's supposed to be the head co-conspirator for Metro. Why would he exonerate him? And then he did go to the DA's office and said, I think we should pursue charges against Compass, and was told, listen, due to this loophole, it's not going to work. Like, you have inconsistent information about what these people are notified or not. And the court records do show that, Cindy Sauerland is identifying, when they want to file on this case or, notify next kin. Like, there's records that match up. So even it's just like, it's literally the exact opposite of what Mr. Tellis wanted to have uncovered by Jappy. And like, he didn't, if he really was out to get him, like, he should have just stopped when the arrest was made and we could be done. But that's not what he does. So I want to get to the defendant's testimony. There's a credibility instruction. You were instructed that you need to consider witnesses, and since he testified, he's a witness, consider his manner upon the stand. Think about what his fears, motives, interests, or feelings are, and the reasonableness of his statements, and the strength and weaknesses of his recollections. And then here's the kicker. Under Nevada law, if you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of their testimony, which is not proved by other evidence. The state would submit to you that arguably, Mr. Tellis' testimony, he might have been our best witness. Based on his manner on the stand, based on the things that he said, he spent 2.5 hours on that first day, and almost 80% of it is talking about things he did in the public administrator's office. It's not about the actual murder or what he's doing on that day. He just wanted to regale you with all of his achievements as a public administrator and how he fought against people standing in his way. And the state would submit to you, as my co-counsel told you in opening statements, that's not what this case is about. It's not about whether he was a good manager or not. It's not about if he had an inappropriate relationship. This is about whether or not he had a motive to kill Jeff Garman, and did he in fact do it? And he did. Think about his difference in how he spoke to you on direct on a narrative versus trying to answer my questions. How many times did I have to repeat, sir, my question is this, bring you back to my question. Sir, I didn't ask you why. I asked you a yes or no. Think about that for a second. Because, and think about this. What are his fears and motivations in this point in time when he sits on that chair and he's talking to you? And we're going to get to something about that I think is very significant. And it's right here. He took the stand and he admitted on cross-examination that he lied during his May 11th, 2022 interview with Jeff German. I asked him, what was it the part that you were untruthful about? And he said it was about my relationship with Roberto. And he said, and I said, you know, he said, I didn't think the public should have to know about that. And it was really important to conceal that information from his family. This is really significant because what it tells you is that back in May, when he was facing just an election, he was willing to lie to protect his job and to save his marriage. Now, the stakes are even higher. They're far higher. So you get to evaluate, are the things that Mr. Tellis is now saying, is it possible he could be lying about some of those details? Because this is far greater than that. Think about the difference in his body language, his ease of sharing information. When I'd ask versus when he just had free reign to say whatever he wanted. They're like night and day. And the state would submit that the defendant's view of this situation is completely divorced from the evidence in the case. It's like he's talking about a thing that's, it couldn't be farther apart. He talks about these conspiracies, but he's so short on details. Always. Oh, he took a bribe. Did you see someone take it? No, I didn't, but it's just in my gut. I think that happened. That doesn't work. That's not evidence. Something in your gut, or I just feel it, that's not evidence. And when you think about it, it does make sense. Because if Mr. Tellis had to be honest about what the evidence is in this case, it's a very difficult thing for him to explain away. It's his DNA underneath the fingernails. It's his car that's there. It's his Google Maps images in his phone. He's conducting surveillance at Popeyes. He's using his computer to look up information on this guy. He's got these text messages explaining how upset he is about everything involving Gehrman. That's a huge problem because really he's the only person who wants Gehrman dead. He's the only one. And really, this was kind of in my mind what jumps out to me. It's like a because I said so. Like when I pressed him on things, like why is this? Why is this? And it was just simply because that's how I feel. That's not evidence. And again, the defendant is also selective during his testimony about what evidence had been compromised versus properly collected. Great example was the scissors DNA. At the beginning, I'm like, the DNA in the fingernail, you couldn't get an inch out of him agreeing with that. I'm like, you at least agree with me that it's been planted, and he didn't even want to do that. But he had come up with a story about cutting his finger, so he's fine with that DNA being on the scissor. That's a nice contrast. You know, and he picked and chose, and you can check your notes on that, but that to me is really significant because he was fine talking about certain pieces of evidence that he thought was good. Great example, the timeline on direct. He's happy to tell you his narrative on direct because he forgets about the where are you. And then on cross, when I confront him with the where are you, now things are a little bit different. But he had no issue with anything in that timeline at first. And another thing, when the defendant testified, a lot of times he didn't use phraseology like, I didn't do this, or I didn't do that, or I didn't stab him, or I didn't go to that scene. It was never that. I mean, maybe from times he would say it, you'll check your notes, but the vast majority of the time, Mr. Tellis would say it like this. I'd like to think I wouldn't do something like this. I'd like to think that I wouldn't do that. I'd like to think I wouldn't take my children's sports balls out of the bag to use for a killing. It's an interesting phraseology. The state would submit it's a bit of a tell. Because he could have just simply said, I didn't do that. I didn't touch that bag. But that's not how he words his behavior. It's this like Monday morning quarterback. I'd like to think I wouldn't because it's really bad. You can weigh that. when you're evaluating how honest and truthful he was when testifying. And again, for all his talk about being conspired against by powerful enemies, it's actually the defendant that uses the power of his office's proprietary software to spy on and discover where Gehrman lives and what type of car he drove. He used the power of the office, Mr. Tellis. And here's another thing. Remember the map that they brought up, kind of trying to show the drive from the PA's office to Popeyes? When you study that, remember it's Analyst Hovanet's testimony. Those reports out of Axiom from the work computer aren't converted for UTC time. So he was trying to use it to say, like, I couldn't have done this at this certain time. It's not UTC converted. And then we get to where are you? Remember, every single message between the defendant and his wife on 9/22 are on the timeline, with the exception of where are you. So here are the messages, where are you? Now they're talking about his daughter, collecting or selling things. Wow, that's incredible. There's a doctor's appointment. Are you at the doctor's appointment? No, we're at the barbershop. Okay. Then there's a text about the scheduling of the appointment, and then he also has picture read. All of that's on that Apple Watch. Oh, and also the deposited message. And then when you look, it's all the same stuff, with the exception of where are you? That's the one thing that's not there. There's the cards thing, there's that's incredible, at the doctor's appointment, the barbershop, okay, the appointment last week, picture day, and then the deposited message. It's all there except for where are you? So why is this significant? Number one, the defendant cannot answer this text or pick up her call because the phone is at home while he is murdering Gehrman. Number two, the defendant couldn't leave this message on his phone. Why? Because it would reveal that even his wife is looking for him at the time of the murder. And third, given the state of their relationship at that juncture, given what you've now kind of acknowledged what he was doing privately, if your wife calls and you have your phone on you, you're going to take that call. You're going to answer that text message. You're not going to let that sit for like 5 hours. No way. No way. Some final thoughts. I want you to think about this one. This is something I never actually asked Mr. Tellis on the stand, and I really tried to ask as many of these, but this one really struck me. The Las Vegas Metro, If the Metro Police Department, the Las Vegas Metropolitan Police Department, was really in on a conspiracy to get the defendant, right, to truly get him, here's a question for you. Why not let him die in the tub? You saw the video. Why not let that man bleed out? You had your opportunity, and yet they don't take it. Mr. Tellis' life is saved that day. And who ends up saving his life? Why, it's none other than the head conspirator from the Las Vegas Metropolitan Police Department. It's Detective Derek Jappy. He testified that he spent 2 hours on the phone talking him off this ledge. 2 hours. And then you got to watch the footage. They saved his life. If the conspiracy is really true, Derek Jappy doesn't do that. Metro doesn't do that. They literally let him bleed out. But that didn't happen. And the reason is, ladies and gentlemen, is because there never was a conspiracy. You made a commitment when we did voir dire to follow the law. The law in this case is abundantly clear. These 3 theories of liability are abundantly clear. He is guilty beyond a reasonable doubt on all 3 theories, and it's not close. And so we ask you to follow the law and follow the evidence. Do not speculate, but follow the evidence. As my co-counsel brought up, in the end, this is not a case about politics. It's not about alleged inappropriate relationships. It's not about who's a good boss or who's a good supervisor or favoritism at work. It's just about murder. And I want to end, if I could, just want to make sure that this is working, with something that Mr. Tellis said in his interview that really struck me. And I noticed it during the opening statement. And it's this.
and people just cannot get to do whatever they want.
And it's just that people don't get to do whatever they want. For once, the state of Nevada is in agreement with Mr. Tellis. He doesn't get to do whatever he wants. He took the life of an individual who was simply doing his job because he didn't like how it impacted him personally. Please hold him accountable for murdering Jeff Gehrman. Thank you very much.
Okay, at this time, the clerk will swear the officers of the court who will take charge of the jury panel.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God?
Yes.
Okay, at this time, ladies and gentlemen, you're going to be excused. When you go back, you're going to have lunch. After lunch, our two alternates, Mr. Max Gross and Zachary Crayson, you will go with one of the court officers. At that time, the clerk will bring back all of the evidence, and you'll begin to deliberate upon your verdict. So when you're done eating lunch, make sure Officer Hawks knows, and the clerk will bring back the evidence. Thank you very much, and you're excused.
Thank you. All right, directions.
Please.
Yeah.
All right, so they're going to be going to lunch, which means we won't have a verdict for at least an hour. When they get back from lunch, there's no telling how long it's going to take for them to reach a verdict. So there's no way for me to put up a notification of when we are going to go back live. We are now on verdict watch. Essentially, as soon as I hear something, I'm going live. I will try to wait to start playing anything for about 10 minutes after I go live, so all of you can join me, give you all time to, see the notification. But I would anticipate anywhere from an hour and a half to probably 3 hours or so that it would take to hear something. At some point, if they take too long, the judge is going to adjourn for the day, and they'll have to come back tomorrow and keep deliberating. So I would anticipate us going live once. It'll probably be pretty quick. Either they'll have a verdict, or we will be just hearing the judge saying that we are adjourning for the day. But let's talk about the defense's closing. So he went through a little history lesson of what it means to have proof beyond a reasonable doubt, why we have that system here in the United States, things of that nature. And then he started talking about what the state doesn't have. And the things he said about what the state doesn't have, to me, I didn't find very compelling. Maybe you did. I didn't find it very compelling. He said, we didn't have Gehrman's DNA anywhere but at the scene of the crime. Well, that is true. He tried to say that there was blood everywhere at the scene of the crime. The state kind of rebutted that by saying, no, there wasn't. There wasn't a bunch of blood split. I'm doing the same thing D.A. Hamner was doing, getting tongue-tied. There wasn't a bunch of blood spatter all over the place at the crime scene. I do kind of take issue with the reference to Gehrman's shoes, because I guess the Gehrman's shoes are indicative of the fact that at least while he was standing, there wasn't enough blood to really kind of drip down onto his shoes. But if he was laying down and that's where the blood was pooling, it likely wouldn't have traveled all the way to his shoes. Be that as it may, it does take a while for blood to pool. So even if there was a large pool of blood at the crime scene when the detectives arrived, if there was evidence of there having been a large pool of blood at the crime scene when the detectives arrived, that does not mean that the day before, when the actual murder took place, there was a large amount of blood at the crime scene. So the idea that Tellis had to have Garriman's DNA all over the place is not necessarily. There was no one with personal knowledge to contradict Tellis's version of events. So apparently the defense wants somebody to have taken the stand who could say exactly where, who could say that Tellis definitely was not at home while this crime was taking place, because that's where Tellis says he was. He says he was at home and he was taking a walk. He also said that he was at the Planet Fitness, but we find out that no, the timeline places him at Planet Fitness after the crime took place. So really, he was just at home and walking around his neighborhood on a walk. The only person that I could think that could possibly come up and say he definitely was not at home is his wife. And the state can't put his wife on the stand. Spousal immunity kicks in. It just doesn't, they can't do it. So that defense it doesn't really work. There's no one who could give a positive ID of the vehicle or of Tellis. Well, again, the state is, the defense is asking a lot here. They're asking that someone to retroactively, I guess, somebody, the police officers find somebody who actually saw this person in this orange outfit and the straw hat to have confronted that person or gotten in close enough proximity to that person to be able to see beneath the straw hat and positively identify Robert Tellis and or positively identify the vehicle for which the license plate has been removed. And again, that's a big ask. The person was obviously in some sort of a costume. So to require that that person be positively identified doesn't really make much sense. And how we rely on license plates to identify vehicles. Unless your vehicle is, gold with green trim, like the only one of its kind on the road, nobody just seeing your vehicle driving by is going to recognize that as your vehicle unless they know your license plate and your license plate is actually on the vehicle. So that's a big ask, especially when we know that there was no license plate on the vehicle. He says, well, the state didn't give you the gloves, the pants, the murder weapon, or the vest. Tellis was obviously in the process of destroying and getting rid of evidence. He was destroying the shoes. He was destroying the hat. Had he arrived back home or left the murder weapon, arrived back home with the murder weapon or left the murder weapon in the car for his wife to find, that probably would have been a problem. Had he arrived back home with the orange vest or left the orange vest in the car for his wife to find, because remember, it's her vehicle. It's the vehicle she drives the most often. that likely would have been a problem. So those are probably the first things he got rid of. The gloves likely had something on them. I would find it hard to believe that no blood would have gotten on the gloves. So again, that's probably one of the first things that Tellus got rid of. Get rid of the things that directly pin me to this crime first. And he can't put it all in the same place, right? If he puts that hat in the same place as the gloves, and anybody who happens upon the place where all of this stuff has been discarded is going to find his DNA on the hat, right? Because we found his DNA on the hat. It was his hat. He had worn it before. And he said it wasn't his hat though, but his DNA was on it. So the idea that we didn't recover everything that was used in this particular crime, that's not a really good defense either. There's no surveillance or eyewitness testimony showing Tellus leaving his house that day. So this crime occurred during regular business hours on a Friday, I believe it was. And he apparently left the home at, let's see, 9:12 a.m. after most people have already made it to work, after most people are in school. So apparently the defense wants somebody who's retired to have happened to have been outside, found it odd enough for Tellus to get into his car on that day, to have remembered that Tellus got into his car on that day at that time with such positivity that when the police canvassed the neighborhood, this non-working person said, "Oh yeah, I remember exactly that day out of all the days because Tellus left at 9:12 and I found that odd." That doesn't make sense. I don't keep track of my neighbors like that. I'm sure you all don't keep track of your neighbors like that. Their comings and goings just kind of happen. And if 3 days from now, even if I see my neighbor leaving the house, 3 days from now, I'm not going to remember that I saw them leave the house, what day it was, what time it was, any of that. I can tell you that sometimes my next door neighbor comes home late because my lights come on. That's about it. Couldn't tell you what days of the week that happens on. But to require surveillance or eyewitness testimony showing him leaving the house that day is a little much. The missing body cam footage. Again, the body cam footage cannot show anything that would have any impact on whether or not this crime took place, whether or not Tellus committed the crime. It can show that Tellus was treated bad. That's about the best it can show as far as Tellus is concerned. It might be able to support a civil rights claim against the police department by Robert Tellus. But as to whether he murdered Jeff Gehrman, it can't show that. So it doesn't matter as far as the defense is concerned. There's no wounds on Telus. So apparently Tellus's defense is only a professional could have committed this crime. But a professional reporter, an amateur fighter at best, someone who we don't know if they have ever fought at all, but they certainly have never had to fight for their life, was required to have inflicted such wounds on Robert Telus that a few days later, those wounds remain to be photographed. And these wounds had to be inflicted on a person who was fully clothed from head to toe. I mean, arms, hands, everything's covered. But the fact that he doesn't have any wounds on his body mean he must not have committed this crime. Again, they're asking a lot. The defense is asking a lot. The lack of response to junk mail messages doesn't prove anything. No, it doesn't. A lack of response to junk mail messages doesn't prove anything. But a lack of response to your wife, that's tough. That's tough. They didn't establish that the phone use behavior was abnormal. So what the defense wants here is, let's say, a month worth of data regarding how Robert Telus responds to emails, text messages, things of that nature, so that we can compare it to his responses on that day. And that's actually a reasonable request, and one that the state likely could have done. They likely could have given us a month's worth of that data. But we do know that on the day in question, he responded immediately to text messages, to personal messages that he received immediately before he left the house that day, and immediately after he returned from Planet Fitness. He's responding to text like a normal person does, not like somebody who's in the middle of committing murder does. So the things the state doesn't have are of essentially no consequence in my mind. So let's talk about the things the state does have. He said that they do have cut-up patent shoes. Why not get rid of them? So your defense to this case is now, why wasn't my client smart enough to get rid of more evidence before the police came? We don't know why your client wasn't that smart. We don't know why he kept this stuff in the house. We don't know why he sat in his living room cutting his shoes into itty bitty pieces before he, I don't know, just took them to the dump or something. We don't know why he did that. He could have dropped them off at pretty much any public trash can, anywhere in Las Vegas, anywhere in Clark County, at any point before the police showed up. But he didn't know when the police were showing up, and it looks like he was in the process of making all of those pieces of evidence even smaller, so if somebody did happen upon them wherever he placed them, they'd have a tough time identifying them with the person who committed the crime. Because remember, Telus didn't know immediately that they were going to have video surveillance footage that depicted the exact pair of shoes that he would be wearing, that he was wearing when he committed this crime, allegedly. because the jury hasn't come back, when he allegedly committed this crime. So when he found out, oh no, they know exactly what shoes I was wearing. When he realizes this, he says, oh no, let me destroy these shoes beyond all recognition. Let me cut them up into such little pieces that nobody will ever know that these were shoes in the first place. That takes time. And he can't do it with his wife watching him. He can't do it with his kids watching him. Which means he has to sit in his living room because he doesn't go to work anymore. He has to sit in his living room and cut these shoes up only when he's alone in the house. That takes time. So in answer to the question, why not get rid of them? Well, because he wasn't done destroying them. He had to have time to do that. The shoulder bag with the balls. I mean, the state did a masterful job of responding to the defense's question about this shoulder bag with the balls in it. The defense said, so he used this in the crime and then he put his kid's balls back into it. And the defense's and the state's answer to that question was, yes, that's exactly what he did. The defense says, well, there's all this sawdust in the bag. The state says, oh, there's sawdust in the bag? Let's have a closer look. No, that looks like little pieces of the hat. And we all saw it. It does look like little pieces of the hat. We never associated it with the hat prior to the state blowing it up for us on the screen at the specific request of the defense. It's like the defense asked for them to do it. And so they did it. And lo and behold, it no longer looks like sawdust in the bottom of the bag. It looks like pieces of a cut up hat. Much like the cut up hat that's in the garage and what the hat used in the commission of the crime would look like if it had been cut up. It says the state has all these cached images on Google Pixel phone and computer, but we don't know who accessed it or created it because it's just cached images. We don't know when it was created. We don't know who created it. Well, only certain people have access to your Google Drive, right? My wife can come into my office at any point. And if she knows my passwords, get on my computer and do whatever she wants and find whatever she wants. Because I'm an attorney, I've got certain things locked behind specific passwords that nobody knows. But my computer itself isn't locked behind, super secret passwords. Just certain things on my computer are locked behind those passwords. The computer itself is kind of open to my wife. She can probably come in and access my email. So is the defense saying his wife did all of this photo stuff? Or one of his kids? Those are the people that we typically associate with shared access to a Google Drive. Who is he saying did all of this? And I'm sure the theory is not his wife was the one walking down the street that day, garbed in this construction worker's shirt with this big hat on, and she was the one driving her vehicle all day. And she was the one texting her husband from her phone saying, "Where are you?" so that it could look like she was the one that was at home and he was the one out committing the murder. Surely that's not what the defense is saying. We do know that these cached images were on his phone at some point. So somebody, likely one of those two, him or his wife, were looking up information about the decedent, Jeff Garriman. They were conducting this investigation into all these cars driving down this street. And they were also conducting an investigation into what Jeff Garriman's car looks like. They were conducting this investigation into all the nooks and crannies of the exterior of Jeff Garriman's home. So it's either Tellis or his wife. And I don't know, but if Jeff Garriman is the one who brought my spouse's illicit affair to the fore, made it so I now know that this illicit affair is going on, that's really not motive for murder for me. Not for the person who brought my spouse's illicit affair to light. Maybe for my spouse, maybe that's motive for that. I don't know. Maybe in her mind, she has a motive now to kill her husband, but not the guy who brought it to light. So that leaves only Robert Tellis. That's the only one left who has access to all of these devices. So then he says DNA under Garriman's fingernails. Well, this was less than an airtight investigation. Those are the words that his defense attorney uses. This is less than an airtight investigation. And we know it's less than an airtight investigation because the CSI person at the scene of the crime couldn't remember who bagged the decedent's hands. Now, we heard an abundance of evidence about the chain of custody of all of this evidence. We know that the hands were bagged at the coroner's office, at the medical examiner's office. And not only were the hands individually bagged, but the decedent's body was bagged, and the medical examiner testified that she broke the seal on the body bag. So no one else had gained access to the body prior to it leaving the crime scene. So we know the CSI people had access to the body at the crime scene. Nobody touches it then before the medical examiner. And when the medical examiner opens it up, the lab tech says, I removed the bags off the hands. So the bags had to be placed on the hands at the crime scene. The fact that we don't know who put them there is of absolutely no consequence. Somebody bagged the hands. If that's all you can point to how sloppy this investigation is, well, that's not evidence of the investigation being sloppy. He said the lab techs were trainees. I don't know if you all remember that evidence, but the testimony was, I've been a lab tech for X number of years, and now I'm a trainee to be the person who actually processes the evidence as opposed to the person who collects the evidence. But this is the lab tech's job to collect the evidence, and I've been doing that for years. At this point, I can process the evidence, but I'm still considered a trainee. That was the testimony. So essentially, this trainee was doing her job that she had been doing for years when Jeff Garriman's body comes to the medical examiner's office. But we're supposed to associate the word trainee with incompetence, with lack of ability to do your job properly. That is not a connection the jury should make, because that doesn't fit with the evidence. The only person who wants us to believe that is Robert Tellis. The Google search of the recipe. The defense said, look, there's 2 computers in Tellus's house and nobody checked those. Maybe he was searching for the recipe for fried rice on one of the computers. What does the prosecution come back and say? Essentially, so you want us to believe that he took his desktop computer from somewhere else in his house, brought it into the kitchen, and searched for the recipe and followed the recipe from his desktop computer, and he took it back. That's just not how people use devices in the normal course of things. The easiest way to follow a recipe when you're cooking is to look it up on your phone. So we searched the phone because searching the computer for the recipe doesn't make sense. So where does the defense get points? I think they get 2 points for their closing statement. The first is when he shows the Yukon Denali entering the neighborhood at 9:10 a.m. on the day that this crime took place, and reminds us that Jeff Mogg said, I don't have any surveillance footage of the Yukon having left the neighborhood prior to that. So what the jury can believe from this evidence, what they are entitled to believe, is that there's more than one red Yukon in that neighborhood, because why would his car, come and go, come back to the neighborhood at 9:10 and leave at 9:12? What was he doing in that time? Because he was answering text messages during that time. Tellus was. He was answering text messages. So maybe there's another burgundy Yukon, maroon Yukon in that neighborhood. And if you recall, even though the defense didn't say it, we didn't hear any evidence about whether or not there were any, that I recall, as to whether or not there were any maroon Yukons registered to any people in Tellus's neighborhood other than Tellus's wife. I don't recall hearing that testimony. But it also begs the question, how good was your collection of video if you couldn't find video that showed this Yukon leaving the neighborhood? And further, we have heard testimony that there was another exit from the neighborhood. If that was Robert Tellus's car that returned to the neighborhood at 9:10 a.m., could it have left by a different point of exit? And if it left by a different point of exit, then perhaps Tellus was coming and going, or his wife was coming and going from this neighborhood by a different exit, and all we're seeing is when they happen to come or go from this particular exit. Celine, thank you for joining us. I understand you got to go. We can't anticipate that they'll be back until 5 o'clock at the earliest. But there's no telling when we're going to have a verdict. So hopefully you can join us for the verdict. I do thank you again for coming and joining us all the way from the United Kingdom. Thanks so much. The second place that they get points is that Denali on Wintergreen Drive. That driver looked like they had hair. Remember, the driver was traveling to the right. When it was traveling to the right on the screen, that driver looked like they had hair. And that did kind of look like a maroon Yukon Denali. So maybe there's more than one, right? That goes back to the fact that Mogg didn't look into any other maroon Yukon Denali's in Clark County, Nevada. Now, I wasn't as convinced that the vehicle that was traveling in the other direction, the driver of that vehicle, also had hair. I wasn't quite as convinced. The zoom did not do justice to that deduction. But there's still that indication that somebody was driving a maroon Yukon Denali with an orange vest on who had hair on the day that this crime took place. So, that's a point for the defense. I got to give it to them. And then the defense got into Compass Realty, and essentially the defense said, look, all right, I know this is crazy. I know this Compass Realty conspiracy thing is crazy. And I know you might think my client is crazy, but just understand my client was investigating Compass Realty leading up to this. And then all of this stuff happens. And then my client's in jail for 2 years. The only thing he can think about is Compass Realty. And it kind of makes sense. So let me show you how it kind of makes sense for him to believe that Compass Realty might be involved. I'm not saying he's involved. I'm not saying Compass Realty is involved. I'm not saying that this is a huge conspiracy. I just don't want you to walk away thinking, I don't want you to go back into the jury pool in the jury room thinking my client can't be believed because he believes in this conspiracy. So let me just paint this picture for you about this conspiracy that I don't believe in. That's essentially where he went with his entire discussion about Compass Realty. I know this conspiracy theory is false, but I don't want you to think that the fact that my client believes that this conspiracy is true means he must have committed this crime. So let me just touch on this. So kudos to him for trying to clean up this whole conspiracy theory thing, because the defense came back and specifically referred to this conspiracy theory. So Natalie wants to know, can Compass Realty sue for defamation? So to prove defamation, there has to be a false statement of fact. It appears to me that Robert Tellis was giving us a lot of false statements of fact that I'm sure Compass Realty can refute. Like, they must have hired this assailant. It has to be published to a third person. So the fact that he broadcast this at the very least, to the entire courtroom satisfies the next element of that crime. There have to be damages to Compass Realty. So yeah, Tellis made Compass out to be professional assassins. So yeah, that's kind of defamatory, right? Or at least to have hired professional assassins. But there has to be damages to Compass Realty. Proving damages in this instance might be a little difficult, but let's assume that Compass Realty was able to allege and prove that either their reputation was harmed and or they experienced some economic harm from the things that Robert Tellis has been saying on the stand. Well, Robert Tellis has a very good defense. Essentially, the things that litigants say in the course of litigation are have a privilege associated with them. You can pretty much say what you want in defense of your own self and get away with it. So all he has to do is kind of raise that as a defense, and Compass Realty would kind of lose on their defamation claim. And that privilege actually extends to at least some extent to their attorneys as well. So I I don't like his chances, Compass's chances of succeeding in a defamation claim against Robert Tellis for the things he said in court. Now, he also did a bunch of jailhouse interviews. And there might be some defamatory statements that were made during those jailhouse interviews that weren't really a part of the litigation process. And if Compass Realty can prove damages with respect to those statements, well, then maybe they have a defamation suit. But Robert Tellis is going to jail for the rest of his life. He's uncollectible. So what's the point? So yeah, that's the long and short of how I would understand a defamation case in that context, Natalie. Thanks for the question, though. So DA Hamner got into this conspiracy and he said, look, let me tell you, let me remind you who all is involved in this conspiracy. It's Compass Realty, it's Adam Finn, Cindy Sauerland, Rita Reed, Alicia Goodwin, Derek Jappy. And with respect to Derek Jappy, we can't say why Jappy would have conspired with all these other peoples, but you know, it's Tellis's gut feeling that Jappy's somehow involved. That's all he's got. So Derek Jappy, we got Cliff Mogg, Justine Gaddis, the entire DNA lab with the Las Vegas Metropolitan Police Department. We've got a smattering of unnamed patrol officers who are involved in this conspiracy. And we've even got the district attorney, D.A. Wolfson, is involved in the conspiracy. All these people are part of the conspiracy. And he kind of tied it all together. Look, you can believe that this conspiracy happened. And if this conspiracy happened, then all this evidence was planted. And the DNA evidence was planted. And, you know, the fact that the vehicles match, that was by design. All of this was a part of the conspiracy. You can believe that, even though there's absolutely no evidence of a conspiracy. You would have to speculate to such an insane degree in order to believe that this conspiracy has occurred and throw out all this evidence. But if you don't do that speculation and that draw that conclusion from your speculation that this conspiracy exists, then you have to believe that this evidence exists, that we found the hat in his house. We found these shoes cut up in hiding under his recliner. And that's probably his recliner. So in my house, I've got a recliner and it's part of my sofa. And one of my daughters, I've got 5 kids. One of my daughters tries to claim my spot on the couch, but it's my spot. It's my spot on the couch. That's probably his spot on the couch. He doesn't have 5 kids. People don't have as many spots to claim on his couch. So that's probably his spot. Nobody probably sits in that spot but him. Daddy's spot on the couch. That's Daddy's spot. Single Pringle, thank you for the subscription. I greatly appreciate it. That's Daddy's spot on the couch. So it only gets reclined when Daddy is sitting in the spot and Daddy reclines in it. There is no possibility that one of the kids is going to recline in that spot because it's Daddy's spot. That his wife is going to recline in that spot because it's Daddy's spot. Perfect hiding spot. Because the only person who's going to reveal it is Daddy, right? Robert Tellis, the only person who's going to recline in that seat, more than likely. So he's got these shoes in hiding, in the perfect hiding spot, so that he can get access to them, and nobody in this house is going to find them. And he's cutting them all up. And if you don't believe in this conspiracy, that evidence is there. We got it from his house. If you don't believe in this conspiracy that you can't believe in because The judge just read you the jury instructions that say you can't just make stuff up whole cloth. There has to be some evidence. If you don't believe in this conspiracy, then you got to believe that Tellis's DNA was under Jeff Garriman's fingernails. And then he started digging at Tellis. He was just digging at him. He basically said, what the hell is a public administrator anyway? And why would somebody conspire to commit murder to get a public administrator in trouble? It's a public administrator. Nobody even knows what you do. But Robert Tellis has come up with this entire conspiracy theory. And the DA Hamner says, that's how important Tellis is to Tellis. And you know what the first thing that came to the jury's mind when he said, that's how important Tellis is to Tellis? The first thing that came to their mind was, I'm 6'5.5". I don't buy name brand shoes to wear to work because I put risers in my shoes. Call it a vanity thing. When DA Hamner says that's how important Tellis is to Tellis, the jury heard, call it a vanity thing. He went on. He just kept digging at him. He said, lame ducks don't matter. And then he reminded us, look, let's say you do speculate and throw out the jury instructions and speculate. Why kill Jeff Garriman? His writing is the writing that got Tellis out of office. He was sought out by these alleged co-conspirators because the co-conspirators include these people in the office, Rita Reed and Alicia Goodwin. These are people who sued Robert Tellis while he was in jail because of the hostile work environment he allegedly created. These are the co-conspirators. They sought out Garriman because they couldn't get any traction with their claims that he was creating a hostile work environment. Why kill him? He was about to make another article outing Robert Tellis, another article that was hurtful to Robert Tellis. That's what the co-conspirators wanted, right? Tellis to be hurt. Why kill him? I must say, I didn't really like the way that the state dealt with the vehicle where you can zoom in on that vehicle passing and see that person having hair. I think he had to deal with it. He had to say something about it. And I think he said the best possible thing he could. And he essentially said, look, it was a construction site. There's a whole lot of construction people coming in, going from the construction site. And when you see that car traveling in one direction, they are coming from an actual construction site that our witness said was blocked off to regular traffic. So if they were coming from within the area that was blocked off to regular traffic, they were probably one of the construction workers. Whereas the vehicle traveling on the other side of the street was traveling in regular traffic. And that was likely the assailant. The reason I didn't like it is not because it wasn't the best way to deal with it. It's just that it reminds everybody there's more than one maroon Yukon. And there could have been more than one maroon Yukon with somebody with this orange vest on. And if you take that dude with the hair and put a floppy straw hat on his head, he would look a lot like the murderer. So of all the things that the defense could have done in their closing statement, I think that was the best thing they could have done. The single best thing. I think it was the single thing that had any compelling nature to it. And I think the DA even noticed that it was compelling, that it had some gravitas to it. And they tried to deal with it, and they had to try to deal with it. But then he tied it all up with, look, and this was kind of a little misleading on the DA's part. So he shows the jury instructions that allow the jurors to look at a witness's testimony, and if they have lied about something material to the case, then they can then choose to throw out everything, right? And he immediately follows that up. He doesn't, with his words, connect the two, but he immediately follows that up with, look, he lied about his relationship with Roberta. Remember? He lied about it. He told Jeff Gehrman that he didn't have a relationship, and he did it all to protect his marriage and his family. So what he was likely trying to do was get the jury to think, well, Robert Tellis lied about that, and that was kind of material. Therefore, we can throw out all of Robert Tellis's testimony. But that's not really how the jury instruction works. It doesn't matter if you've lied about something in your past, because if that was the case, anybody who takes the stand in any case, the jury can throw out all their testimony, because we've all lied about something at some point in our lives, right? So the fact that Tellis lied about something before taking the stand, he lied about something in the past. In the past, he committed the act of lying. The fact that he did that doesn't give the jury carte blanche to throw out all his testimony. He has to have lied about something on the stand. They have to believe that he lied about a material fact while he was on the stand as a witness. But the DA kind of connected those two as if to say, because he lied about this, you can throw out all of his testimony. So that was a little sneaky on their part, on the part of DA Hamner. But he did a good job of saying, look, he lied about his relationship with Roberta to protect his marriage and family. He's now on the stand trying to protect himself from going to prison for the rest of his life. If he could lie about that for that reason, how much do you think he's lying about on the stand in this case? So all in all, I actually think both the DA's office and the defense did a very good job with their closing arguments. The defense just didn't have much to work with. They were swamped by evidence, and all they had was a conspiracy theory. So they did what they could. The defense did what they could with what they had to work with. And they did an admirable job of it. That one point that I gave them for the guy in the Yukon with the hair, I don't think that was enough. I think we are going to see a conviction here. But I don't know when we're going to see the conviction. So for now, I'm going to get off of here. I'm going to come back live as soon as the court restarts. I do hope all of you will join me. I do thank all of you for joining me up to this point. If you haven't been here for the entire trial, as always, if you have any questions, drop them in the comments below when this video posts. And I will try to answer it before the verdict comes back, but I don't know. It depends on how quickly we get a verdict here. But I'll try to answer any questions as quickly as possible. And again, I do thank all of you for coming out. I hope you rejoin me to hear the verdict. And if you're not already a subscriber, please subscribe, because we are going to be doing this again in another case very soon. So hit that like and subscribe button. For now, my name is Nathan Saunders, and this is The Legal Good. Denny Dawn, while I'm here, let me answer your question. Yes, I am an attorney. I'm an attorney in Florida. I have been practicing law for 10 years now. Almost 11? Something like that. It's been a while. And I'm still a practicing attorney. So yes, in answer to your question. So if you want some legal analysis during these court cases, that's what I am here to do. So hit that subscribe button so next time you can join me for the entire case. Thanks for joining me for this one, Denny. You can't take the ones on court. I understand. All right. Again, this is Nathan. This is The Legal Good. Join me for the verdict. Thanks so much.